Government of India. He has been recognized for his exceptional legal acumen and has contributed significantly to the development of legal policies and reforms. Next on the panel, we have Mr. Pubudu Sachidanandan, who is working as a trial lawyer at the International Criminal Court for over 9 years. He hails from Sri Lanka and has extensive experience in the field of international criminal law. We have Dr. Sanoj Rajan, who is a renowned legal expert in the field of international law and human rights. He is a distinguished professor of international law and human rights at Zhejiang Gongshang University, China. Finally, we have Dr. Anirudh Rajput, who is an Indian legal scholar and a renowned expert in international law. He was a member of the United Nations International Law Commission from 2017 to 2021. With this, I now declare the final rounds for SICTA 2023 open.
Good afternoon, everyone. I'll be the chamber master for the final round. I'll be keeping time for every statement according to the clarifications provided, and I'll provide warning as and when required. Reminders will be given for 5 minutes, 2 minutes, 30 seconds, and whenever the times are up. We can now proceed with the Victims' Council application for recharacterization of facts. Thank you.
May it please the court. Counsel seeks permission to collectively address the bench as Your Excellencies.
Please go ahead.
Much obliged, Your Excellency. The victim's legal representative.
We can't hear anything. Could you start again? And will it be possible to spotlight the speaker as well? Thank you very much.
And have their names as well.
May I, Your Excellencies?
Yes, please go ahead. And we don't have your name, victim speaker.
Much obliged, Your Excellencies. May it please the court. A very good morning to the Honorable President, Your Excellencies, and respected colleagues on the sides of prosecution and the defense. On behalf of the victims, we stand here today in the case of the prosecutor and Paul Anderson concerning the war crimes committed by the accused under Article 8 to B20 of the Rome Statute for the war crime of employing weapons which cause superfluous injury, unnecessary suffering, and which are inherently indiscriminate in violation of international law of armed conflicts. We would like to include the war crime under Article 8 to B1 of the Rome Statute, for which we are making this application. I am Speaker 1, and I will be making the application and conducting the examination in chief of the witnesses, and my co-counsel would conduct the cross-examination of the witnesses and make the closing statement. Today, we gather here to seek justice for the most egregious war crimes committed against the innocent civilians population of Emerald City. The victims in this case have faced terrible physical and psychological harm. Many civilians had to resort to staying hidden under bunkers since the war began, for months on end. Between October 22nd and October 24th.
Sorry to interrupt right at the beginning, Mr. Counsel. We don't have your name, so we'll address you as Mr. Counsel, and I hope you won't mind that, unless you decide to give us your name.
Indeed,
it depends on the rules. We're not sure if you're allowed to give your names. Anyways, so my question is, you are seeking recharacterization of the alleged actions. Am I correct?
Yes, Your Excellency.
Could you please address us why do you think this recharacterization should be done? Because we would have presumed that the prosecutor has done their homework very well and on detailed examination and thoughtful reflection brought the charge that they have brought.
Your Excellencies, the recharacterization here is under Article 8 to B1 of the Rome Statute, which establishes the intention of the
Sorry, could you also tell us what is the procedure under which you're seeking this recharacterization?
Your Excellencies, under Regulation 55 of the regulations of ICC, Your Excellency.
Are there any tests on how this recharacterization can take place?
Indeed, Your Excellencies. To mention, the recharacterization must not exceed the facts and circumstances and the scope of the trial that is being conducted in this case, Your Excellencies. Only then such a recharacterization of the charges will be accepted by the court, Your Excellencies.
Are there no further conditions apart from that?
Your Excellencies, those are the conditions as far as the council mentioned, Your Excellencies. Much obliged, Your Excellencies. Your Excellencies, the victims in this case have faced terrible physical and psychological harm. Many civilians had to resort to staying hidden under bunkers since the war began for months on end.
I'm very sorry again. You still haven't responded to my first, the one which I started with, is why do you think the prosecution's characterization is inappropriate and yours is the right one? We wish to understand the gap between the two.
Your Excellency, the prosecution does not intend to say that the examination conducted by the investigation conducted by the prosecution is not relevant. However, the victim counsel mentions that here intends to bring the problems and the harm caused to the victims in the present case, representing the civilians as victims in the present case, Your Excellencies, to elaborate on the impacts that has caused on the present case, Your Excellency.
Yeah, but they have been already taken into account by the prosecution, haven't they?
Your Excellency, we will address it soon. The prosecution did not address the rights of the victims who are civilians into account, Your Excellencies, which are not necessarily covered under Article 8 to be 20, Your Excellencies.
Okay. Yeah, proceed.
Much obliged, Your Excellencies. Between October 22nd and October 25th, vacuum bombs were deployed on civilians 7 times, causing more than 600 deaths, and the survivors had trauma wounds and burn injuries caused by the military-grade explosions. The weapons also struck down many tangible...
How many times were the bombs dropped, you said?
Your Excellency, 7 times.
Could you tell us which page of the fact specify? You're going to come to that, I suppose. Are you going to establish through oral evidence or you have documentary evidence for that?
Indeed, Your Excellencies, through the witnesses, we would establish the same.
We'll wait for
however,
you.
I would like to direct you to the same.
No, that's fine. We'll hear from the witness. That's better.
Much obliged, Your Excellency. The weapons also struck down many tangible assets, including 70% of all the habitable areas, comprising major hospitals, medical stores, water reservoirs, and shelters, causing irreparable damage to the environment of title. Your Excellencies, the atrocities committed against innocent civilians are unimaginable, and the evidence presented before this court will show that the accused admitted that specifically civilians were targeted, leading to the conclusion that the accused is responsible for these heinous acts of war crimes. In light of the same, we would like to request to the court to invoke Regulation 55 of ICC regulations to recharacterize the charge against the accused. If this is not done, it would minimize the scope of this trial by not reflecting that the actions of the accused that caused great harm to the victims required mens rea. Therefore, the application for recharacterization shall be argued under 3 limbs. Your Excellencies, firstly, the chamber must allow the recharacterization as it does not exceed the facts and circumstances of this case. Secondly, the right to fair trial to the accused will be prejudiced by allowing a recharacterization. Will not be prejudiced, Excellency, apologies, will not be prejudiced by allowing a recharacterizations. Lastly, the recharacterizations reflects the true individual criminal responsibility of the accused in the present case. Your Excellencies, if I might direct you to page number 13, para C. We have been authorized by the pre-trial chambers in the present case as the victims' legal representatives. As the representatives of the victims' community, we have a solemn duty.
We don't spend time on that. We are aware of those technicalities.
Okay, if I may proceed.
You have a standing, yes, we are aware of that.
Indeed, Your Excellency, much obliged. Your Excellencies, through the course of the trial, we will present compelling evidence that demonstrates the guilt of the accused beyond a reasonable doubt. We will show that they are engaged in the systematic targeting of innocent civilians through the use of the coordinated attack and positioning of thermobaric bombs to cause as much as harm possible to the civilians. Therefore, we urge this court to carefully peruse the evidence presented and to consider the gravity of the crimes committed. The victims and the families deserve justice, Your Excellencies, and it is our duty to ensure that they receive it. In light of this, we ask this court to hold the accused accountable for his actions resulting in the commission of war crime under Article 82B1 of the Rome Statute and accept the application for recharacterization. We hope that the justice is served to the innocent victims in this trial. Thank you, Your Excellencies. I now leave the floor to my learned prosecutor.
Am I audible and visible?
You're audible but not visible, to me at least.
Could the chamber master confirm if I am visible and my camera is on? This from my end.
You're still not visible.
Your Excellencies, my camera is on. Would the chamber master be able to assist with this?
Now you are able to.
Yeah.
Much obliged, Excellencies. May it please the court, the prosecution would like to address the judges collectively as Your Excellencies. Good morning to everyone present. Mr. President, Your Excellencies, learned counsels, and the witnesses in the present case of prosecutor versus Paul Anderson for the act of war crime under Article 82B of the Rome Statute. In the present case, we represent the office of the prosecutor. I am speaker number 1, and I will be making my opening statement and conducting the cross-examination of witnesses. And assisting me is my co-counsel, who will be conducting the examination chief of witnesses and making the closing statement. Your Excellencies, the present case relates to the war crime committed on the civilians of Titan, not directly taking part in hostilities in the armed conflict between Republic and Titan. Approximately 600 people were killed, which included hundreds of civilians who were in no way associated with the armed conflict. The accused in the present case, Paul Anderson, is a commander in the Republican Army who ordered and commanded the Delta Force 5. He personally formulated the plan and executed the attacks on the civilians in hiding shelters in the Emerald City using modified and prototype vacuum bombs. By the virtue of his acts, the prosecution has charged the accused under Article 8, Paragraph 2, Clause B, Subclause 20, which entails employing weapons and methods of warfare which are of a nature to cause superfluous injury or unnecessary suffering, or which are inherently indiscriminate in nature. Further, by the virtue of the application of recharacterization of fact by the VLR, the prosecution will support the same and argue that the accused is liable under Article 82B1, and this charge entails intentionally directing attacks against the civilian population, not taking direct part in hostilities. The prosecution shall rely on such facts to substantiate broadly 4 arguments. Our first submission is that the accused is liable under Article 82B1 since the required elements are fulfilled as followed. A, the attack on the Emerald City by the accused was in the context of an ongoing international armed conflict between Republic and Titan. B, the accused was aware of the factual circumstances of the attack. C, the accused directed an attack. D, the object of the attack was a civilian population not taking direct part in hostilities. E, the accused intended the civilian population to be the object of the attack. Moving on to the second submission, the use of vacuum bombs was violative of Article 82B20 of the Rome Statute since A, they caused superfluous injuries or unnecessary suffering. B, the vacuum bombs qualify as being indiscriminate in nature. And C, lastly, the weapons used implicitly fall under the prohibition. And with reference to the same, just for a brief moment, I may point the attention of Your Excellencies to page number 39, note to the compromise, para number 3, where it is mentioned that it will be assumed that the charge confirmed against the accused and the annex for the same has been duly included in the annex and with strict compliance of the Article 121 and 123. And we are not to raise issues regarding the inclusion of the same in the annex. May I proceed, Your Excellencies?
I have
Yes.
a question before you do that.
Yes, sir.
You are supporting the recharacterization.
Indeed.
Now, let us understand, it's a different offense altogether.
Yes, Your Excellency.
So, are you going to present any additional evidence, or you're going to simply piggy bank on the evidence of the victims, I'm just trying to understand where you stand on that.
Your Excellencies, we will through through the examination in chief and cross examinations conducted by the counsel for the prosecution, we will establish the same. And as and when required, if there is any assistance provided from the testimonies of victim witnesses, the same will be established. And may I continue, Your Excellency?
Yeah, but why did you not move to amend the charge then?
Your
On your
Excellency,
own side? Why did you not move to amend the charge from your own side as prosecution?
Your Excellency, for to that, may I refer to page 11 of the compromise, para number F.
Yeah.
Wherein we substantiate the reason why this charge was not included at the preliminary stage of investigation, because and the same is not to be taken as a confirmed opinion that the role played by the residents of Emerald City against the Republican forces, there was a chance and a possibility that they might have lost their protected status, and hence the charge was not included in the first place.
Yes, which argument is against your position, isn't it?
Your
Which means
Excellency,
you should not be supporting recharacterization.
Your Excellencies, for the same, we established that we will be able to establish the elements of Article 8(2)(b)(1) as entailed in our first submission, and we support the legal characterization since the facts have not been changed.
Well, but how do you get out of the paragraph F then, where you have yourself said that your preliminary view is that that the individuals may have lost their protected status
Indeed, Your Excellencies.
under
For that,
Convention 4?
Indeed, Your Excellencies. For that, may I point out to the last line, whereas, however, the prosecutor has clarified that his opinion should not be construed as a final determination of the same.
Yes, which is fine, but you need to tell us why this change of mind has happened. There has to be something to fill up the intellectual gap, right? I mean, when we are deciding, we simply can't say prosecution changed its mind, so let's go with it. You'll have to give us some material to at least some pointers, or you can point to us that these are the matters which will come out in the evidence, which we should look for, which would help us to see that recharacterization is the appropriate way forward.
Your Excellency, being an officer of the court, the prosecution was entrusted to conduct the trial in the utmost fairness possible, and hence, since there was a slight doubt regarding their status, their protected status, the same was not included from the beginning. But it is not to be construed that it is the final position, and hence the legal characterization is not contested. And for the same, may I answer the question by Your Excellency?
Well, what happens, because you've raised an important point, what happens in situation of doubts? We are in criminal proceedings. What's the mandate of the Rome Statute when there is doubt? Should an offense be broadened or it should be narrowed?
Your Excellencies, since as per the current factual circumstances, since
Sorry, it's a legal question. It's a legal question. What happens in law when there is a doubt under the Rome Statute?
Is Your Excellency pointing me towards a certain statute of the Rome Statute?
Yes, if you can. Yeah.
Your Excellency, since I've exceeded the time by 2 minutes, may I seek an extension for the same?
Surely, yes. Why not?
Your Excellencies, I apologize that we will not be able to assist you at this moment. May we address this proposition in our closing statements?
I look forward to that. Yes. Thank you.
Your Excellencies, may I continue with my submission, and I will quickly wrap this up.
Yeah.
Our third submission being that the accused is individually criminally responsible under Article 25(3)(b) of the statute for coordinating the use of vacuum bombs. The action satisfies the objective requirements laid out in the Kodak and Circus trial, which are: A, he was in a position of authority, being a military commander. B, he ordered and coordinated the attacks using vacuum bombs. And C, his conduct had a direct and substantial effect on the crime committed. This provision is accompanied by the subjective requirement of mental element as entailed in Article 30, subclause 1, and it is submitted that the accused possessed the same for ordering the commission of the crime. Our fourth and final submission is that the accused cannot claim the defense of duress provided under Article 31D of the Rome Statute, as A, the accused was not under an immediate threat to death or serious bodily injury. B, there was no existence of the threat. C, the situation was within the control of the accused. The accused did not necessarily and reasonably prevent the threat. And lastly, the accused intended to cause greater harm than one sought to be avoided. Thus, the prosecution submits that Paul Anderson did commit the acts of war crime and will incur responsibility under Article 25(3)(b) and 28(a). No defenses are applicable in the current case. With this, the counsel would like to end his opening statement, and we hope to substantiate everything cited in our statement through our examinations and cross-examinations. Thank you, Your Excellencies.
Good morning to everyone present here. I am speaker number 1 on behalf of the Defense Counsel. I would like to confirm if I'm audible and visible.
Yes.
Yes.
Much obliged. The counsel seeks permission to address the bench collectively as your honors.
I think you might maintain consistency with your excellency since it's already been started. Not that we desire a higher designation, but I think just for consistency.
Much obliged, your excellencies. May it please the honorable court, I am speaker number 1, appearing on behalf of the defense in the present case of prosecutor versus Paul Anderson. Your excellencies, I will be delivering the opening statements and conducting the cross-examinations of the witnesses, and my co-counsel will be conducting the examinations in chief and delivering the closing statement. If your excellencies permit, the counsel would like to proceed with its opening statement. Much obliged. Your excellencies, it is indisputable for a conviction under the Rome Statute to happen, the burden is on the prosecutor to prove beyond reasonable doubt that the accused is liable of all elements of the crimes that he has been charged with. However, as stated by the prosecution in the opening statement itself, the prosecutor has prima facie already created a doubts in the mind of the people by going back on their determination on the protected status of civilians, thereby the presumption...
Sorry, let me interrupt you right here. No doubt has been created yet because we haven't heard the evidence yet. So let's not go down that path. We still have to hear the evidence. But I agree with you that we have to decide beyond reasonable doubt. So I think you can move to your next submission to save time.
Much obliged, Your Excellencies. Your Excellency, the primary issue in this case is whether the accused was justified in carrying out the attacks on Emerald City pursuant to the siege of Emerald using vacuum bombs between October 22nd to October 25th of 2022. Your Excellencies, the counsel would like to bring to your attention the incident that led to the attack by the Republicans. The Titanian government had requested the civilians to act as their eyes and ears of their defense forces. It is pertinent to note that the siege of Emerald was particularly designed using the information posted by the residents of Titan and caused the loss of 120 soldiers, countless support staff, and loss of military assets worth millions.
Counsel, I'm sorry to stop you while you were in mid-flow. So just so we understand, is it your position that the entire population had lost protection because of this eyes and ears argument, or a subset of the population?
Your Excellencies, we would like to argue that the majority of the population had lost their civilian status because of their direct participation.
So am I right in thinking that the thermobaric weapons were aimed at the entire population, or was it in some way targeted at this eyes and ears subset of the population?
Your Excellencies, the vacuum bombs were targeted at the military objectives and the military targets in the city of Emerald City. And yes, Your Excellency.
Sorry, how do you substantiate? Are you going to present any lead, any oral evidence to substantiate your argument
Yes,
of military targets?
Yes, Your Excellency.
Okay.
Your Excellencies, if I may continue.
Yeah.
No.
During the war in Emerald City, the information posted by the people of Titan also succeeded in carrying out 3 airstrikes on Republicans' territorial battalions using this information. There was no means to distinguish between civilians and men in uniform. Consequently, there were a set of turbulent orders issued by the President of the Republic to carry out the alleged attack, and the accused could not derogate from it, Your Excellencies. In this background, the defense counsel is going to prove that Mr. Paul Anderson is neither liable for the war crimes that has been charged with, nor under individual criminal responsibility, since the same was done under explicit superior orders issued by Mr. David Wallace, the President. With respect to the charge under Article 82B20, the defense...
Sorry, counsel. I'm so sorry to stop you again. So when you say superior orders, are you making an explicit reference to duress, or are you not making a reference to duress in this context?
Your Excellencies, we are.
Just a supplement. Only duress, but also superior.
Both, Your Excellencies.
Okay. You may proceed.
With respect to Article 82B, the defense submits that the subjective elements have not been met, such as the weapons were not of a nature to cause superfluous injury or unnecessary suffering, or were inherently indiscriminate. Further, Your Excellencies, it is very pertinent to note here that there is a conjunctive requirement pursuant to the word "and" under Article 82B20, such that the weapons should be subject to a comprehensive prohibitions and should be included in the annex to the statute, have not been satisfied. Even though it is a fact that vacuum bombs were not included in the annex to the statute, even though it is a fact that vacuum bombs were included in an annex to the statute, there is no legal instrument that prohibits the use of vacuum bombs. Your Excellencies, I have seen that my time is up. However, could I get a 1 minute extension to close my arguments, close my opening statement?
Yes, you can, but I have a question now, defense witness. So is it your position that this majority population who were called upon to be the eyes and ears directly participated in the hostilities?
Yes, Your Excellencies, that is our submission.
And you're going to lead evidence?
Yes, Your Excellencies.
All right, thank you. So you may conclude here.
If I may, I was a bit startled by your argument on subpara 20 when you said there is an and just because it's included in the schedule, that's not sufficient. But the first test is a general test, isn't it? Are you going to address it now, or you will address it in the closing? I suppose you'll come to it in the closing.
Yes, Your Excellency.
Yes.
Okay,
Good. Yeah.
Your Excellencies, during the course of the trial, the counsel would endeavor to prove that the intention to add the charge of Article 82B1 of legal recharacterization invoked by the legal representatives is not maintainable. This is because the material elements, one, that the object of the attacks was civilians not taking direct part in hostilities, and number two, the accused intended civilians not taking direct part in hostilities to be the object of the attack, have not been satisfied, Your Excellencies. Your Excellencies, apart from fulfilling the conditions laid down by the law, the Counsel for Defense intends to strengthen the arguments made today through witness examinations that will follow. If Your Excellencies have no further questions, this concludes our submissions for the opening statement today. Thank you, Your Excellencies.
Thank you.
May the prosecutor, Your Excellencies, if we have the permission, may the prosecution counsel proceed with the chief examination of prosecution witness 1.
Go ahead, yeah.
Much obliged, Your Excellencies. Your Excellencies, the witness we have here is an expert witness. PW1, are you here?
Yes.
Mr. Umberto Eco, are you here?
Yes.
Your Excellencies, if before proceeding with the chief examination, if I have the permission, I would like to administer the oath pursuant to Article 66 of the ICC Rule of Procedure and Evidence.
Yes, go ahead.
Much obliged, Your Excellencies. Witness, please repeat after me. I solemnly declare.
I solemnly declare.
That what I shall state.
That what I shall state.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Witness, please introduce yourself to the court.
I am Umberto Eco, an former advisor to the Special Tribunal for Lebanon, and I'm 50 years old.
Thank you, Mr. Umberto. Mr. Umberto, could you please tell the court what experience do you have in the current field that qualifies you as an expert today?
So I have an experience of 30 years in the field of high-stakes criminal prosecutions. I also advised judges of the Special Tribunal for Lebanon relating to the terrorist attacks that took place in Lebanon in 2005.
Thank you, Mr. Umberto. Mr. Umberto, could you please tell the court how will you assist the court today?
So I wish to provide my insights on the use of vacuum bombs and to testify in favor of reading vacuum bombs as weapons which are prohibited under international law.
Thank you, Mr. Umberto. As you just stated about vacuum bombs, could you please tell the court the nature of vacuum bombs? How do they function per se?
So the science behind thermobaric weapons is pretty simple. And the vacuum bombs are a subset of thermobaric weapons. They basically use chemicals to alter and modify the environment. The weapon operates to modify the composition of gases in the environment even before the detonating shot. This mechanism and functioning further distinguishes it from most conventional weapons, which instead use oxygen only in the context of the support required for any form of combustion to happen.
Thank you, Mr. Umberto. Point to be noted, Your Excellencies, that this weapon, vacuum bomb, modifies the environment. I may proceed with the next question. Mr. Umberto, as you mentioned, that thermobaric weapons are different from the conventional weapons. Could you please tell, are they different in the damage they cause?
So thermobaric weapons, they are different, yes, because they destroy mines, caves, buildings, and other such spots that were traditionally considered safe from conventional weapons. The use of these weapons cause widespread damage to the environment and infrastructure. And especially in terms of impact, the impact of thermobaric weapons on tangible properties, nature, and the environment of an area is much more wider in radius than that of traditional weapons and explosives.
Thank you, Mr. Umberto. Mr. Umberto, as you just told about the damage that they cause in the environment, could you please tell the damage they cause to the victims?
Yes, certainly. So the effects of these weapons is spread in nature, not just limited to infrastructure and environment, obviously, as you stated. They severely impact the victims too. These weapons have a severe, long-lasting impact on the victims, and they can basically impact all the major organs. In fact, if I may mention, because it utilizes all the atmospheric oxygen of a given area for combustion, a vacuum or rarefaction is created, which basically causes all the humans within the radius of this bomb to die of suffocation or ruptured lungs, basically to cite some of the effects.
Thank you, Mr. Umberto. Mr. Umberto, as you said about the consequences of this weapon, could you please tell the court about the legality of such weapons?
Yes, definitely. It is because of the design and nature of thermobaric weapons that the use of these weapons during an international armed conflict falls foul of existing treaty-based prohibitions. The choice of thermobaric weapons should be adjudged unlawful because only such judgment will allow a desired deterrent effect towards a global disarmament.
Thank you, Mr. Umberto. Point to be noted, Your Excellencies, that the witness has said that these weapons, the vacuum bombs, falls foul of the existing treaty-based prohibitions. Moving further, Mr. Umberto.
Counsel, I'm so sorry to disturb. Just for our understanding, is this witness being called as an expert on legal issues as well? Just so we understand.
Your Excellencies, yes, as this expert witness was the former advisor to the Special Tribunal for the Lebanon.
I was restraining myself, but since my brother judge has asked a question, I'll probably pose it now itself. You started off by saying he's a technical expert. So is he a technical expert or he's a legal expert now?
Apologies, Your Excellencies. I may have said that he's an expert witness.
But I think I'll pause there because I don't want to ruin the cross-examination. I want to hear the cross first, and then if I need something, I'll come back. Thank you.
Indeed, Your Excellencies. If I have the permission, may I proceed with the chief examination?
And also, if you may, and also the other counsel, if you avoid making a reference to point to be noted, we are noting everything, and when you come to the closing, you can note what ought to have been noted from the evidence. So it just saves time, and it's just not decent advocacy. Thank you.
Indeed, Your Excellencies. I would just like to inform the court that just for the relevance, this witness has 30 years of the of experience in high-stake criminal prosecutions. I would move on to my next question. Mr. Mboto, could you please tell the basis of the interpretation of weapons? As you just said, these weapons are prohibited. Could you please tell the basis of this statement?
Yes, certainly. So the text of any international treaty has to be read in the context of the developments that basically predate its creation and enforcement. For example, the use of mustard gas and the likes in concentration camps of the day inspired the framers of the text to leave enough flexibility to enable them to update the scope of these treaties to new classes, types, and categories of weapons. Now, in the context of thermobaric weapons, I would like to mention that the Environmental Modification Treaty, Article 1, it states that each state party to the convention undertakes to not to engage in military or other hostile use.
I'm so sorry to interrupt, but is NMOD convention involved here, Mr. Witness?
Yes, Your Excellency, I do believe that the Environmental Modification Convention, Your Excellency, I'm citing this to basically show that the thermobaric weapons should be banned in.
I'm very sorry, that's a digression. It's just going to waste our court's valuable time because NMOD convention, nobody's alleging its violations, and it's a high standard anyways. Nobody is in a position to meet it. So let's not get into the discussion on NMOD convention.
My apologies, Excellency.
All right, let me come with the question then, Mr. Umberto. What's the consequence if this weapon is not listed under that comprehensive annexure as a prohibited weapon? So has there been any judicial interpretation of that?
Your Excellency, I do not believe that there has been any judicial interpretation with regard to the Environmental Modification Treaty. No. However, if Your Excellency wishes to know about the consequences of non-inclusion in that specific treaty, then I would like to mention that the Article 1 of the said treaty basically calls upon the state parties not to use any weapons during military conflicts that would modify the environment. And as I have mentioned earlier, this weapon does cause pressure changes in the atmosphere to deprive the targets of the oxygen, thereby rupturing their lungs. So,
yeah, but this court is applying international law. So we look at Article 8, we look at the attachment, the annexure, and it seems to appear as if this weapon is not unlawful under the international law at the moment.
That is correct, Excellency.
So you have to convince us on why the court should make the mental leap and put it in there.
Right, Your Excellency.
Your Excellencies, if I may.
Yes.
I would just like to submit that the prosecution counsel is completed with the chief examination, and the witness could, and my learned counsels from the defense and the victim can go further with the cross examination.
Thank you.
Your Excellencies, can I be seen and heard?
Not seen.
Now, yes, I think. Yeah.
Much obliged, Your Excellencies. May it please the court, the victim's legal representative seeks permission from the bench to cross-examine prosecution witness number 1.
Yes, go ahead.
Much obliged, Your Excellencies. Witness, can you confirm that this is your written communication given before the office of the prosecutor and signed? For the benefit of the court, the counsel is referring to page number 16 of the compromise.
Yes, indeed. The testimony is mine. Yes.
Thank you, witness. Can you take the court through how thermobaric bombs are launched?
So basically, it basically depends on the kind of thermobaric weapon used, right? Some of these are used in grenade launchers. Some are used as missiles. So it really depends on the kind of thermobaric weapon you're referring to.
The counsel is referring to the thermobaric bombs that were deployed in the present case. Can you explain to the court how those would be launched?
So I'm not well versed on the facts of the case to be able to judge what nature of the weapon was.
Sorry, Madam Counsel, is this a factual witness or an expert witness or witness of opinion?
It's an expert witness, Your Excellency.
So witness of opinion, I think it will be better if you don't pose factual questions to him because he won't be in a position.
Much obliged, Your Excellencies. In your opinion, can bombs bring down buildings and tanks?
Yes, obviously they can.
I think he has already, isn't it? In his examination, he has addressed some of these questions. Yeah.
Much obliged, Your Excellencies.
Try to ask things which have not come out in evidence.
Much obliged, Your Excellencies. The gases that are released by thermobaric bombs, can they choke victims?
Yes, they can.
Thank you. Can you explain the degree of
I'm so
impact?
sorry, madam. You're asking too many leading questions. Or you're cross-examining.
Yes, Your
Oh, you
Excellency.
cross-exam. Apologies. I thought because I was under the misimpression that you are conducting the examination in chief. Go ahead. You're absolutely right. Sorry.
Thank you, Your Excellency. Could you explain the degree of impact on surviving victims after a bomb is launched?
So I would like to add to this the fact that you had mentioned of the use of gases. So in the backdrop of that, right, gases such as ethylene oxide or propylene oxide are used in the targeted area. And these in the second stage of the explosion, they ignite the fuel, which create a massive blast wave and fireball, which can cover an area of 2.5 miles.
Okay, thank you. Is it possible for victims to safeguard themselves once the bomb has already been launched?
No.
Thank you. What degree of medical assistance would be required from these victims after the bomb has been launched and as an attack on them?
So as I mentioned that since after the explosion, after the second stage, the people are, as a result of the oxygen basically deprivation due to the rarefaction, right? So people may suffer not only burns, but also collapse of their lungs and the pulmonary function. So although I'm not a medical expert, I would believe that a very high degree of medical care would be required in such cases.
So would it be true to state that this medical care would be of a high degree and incredibly urgent?
Yes.
Sorry, you just said he is not an expert on medical and he can't give information on medical issues, madam.
Your Excellencies, the council was asking this question because the witness is an expert on bombs and has studied the effect of bombs as per his testimony.
But he just said he can't. He doesn't have expertise on medical issues. And you asked the second issue about how much is the medical help required.
Much obliged, Your Excellencies. Council will move on. In your experience, what would be the cost to repair damage caused to the environment after these bombs are launched?
So see, basically the impulse which is created by the explosion, it is very powerful enough and it can damage not only basically those structures which were traditionally considered to be protective, like bunkers and also other protected areas, but it can also cause a lot of human damage, like damage to internal organs, etc. From the little medical knowledge that I have, and traditionally protected spaces, especially for example in the usage by the United States of America in the thermobaric bomb which they used in Afghanistan in 2017, it had caused a lot of collateral damage to the existing structures.
Would it be true to state that the costs to repair property and the environment would be very huge?
Yes.
No further questions, Your Excellencies.
Thank you.
Your Excellencies, the counsel for the defense would seek permission to cross-examine the witness.
Yes, please go ahead.
Mr. Umberto, my first question, just for a clarification, do you know the radius of the vacuum bombs that have been deployed in the present case?
I think that would be a factual question. So no, I do not.
But in your previous testimony with the cross-examination of the victim counsel, you just stated that the radius is 2 to 5 miles.
I did not say 2 to 5 miles. I said that generally the radius can be 2.5 miles. Generally, that is a basic assumption with regard to thermobaric weapons. Yes. However,
since you're an expert witness, would it be correct for you to make assumptions because the court and because the evidence is relying on you?
Yes, sir. No, see, this is not my personal assumption. This is a scientific assumption that I'm telling you, that generally it is regarded to be 2.5 miles, an entire radius which is covered by these bombs. It can also go up as high as 10 kilometers in range. But an accepted scientific assumption is 2.5 miles.
You are constantly stating that it is an assumption or it's a general fact. How do you come to this generalization? Like, what is general for you? Does this specific information come into this generalization of yours?
See, this is not a generalization of mine. Like I just said, this is not a personal opinion. This is a scientific evidence which I'm just citing.
Moving on, you have
could you give us what is the source of that scientific evidence, if you have?
Your Excellency, I would not be able to point to the exact weapons.
Doesn't matter.
Right. However, Your Excellency, the kind of thermobaric bombs which I'm talking about are those which are especially used in cases
Sorry,
of...
I meant the source. I'm so sorry to interrupt. I meant the source. You can give us published so-and-so scientific journal in issue so-and-so, year so-and-so.
Your Excellency, I'd have to cross-check that information. I'm not exactly aware right now.
No problem.
Moving on, Mr. Amboto, you stated that you are to be considered as a legal expert opinion, right? Am I correct?
Yes.
So would you tell us that in your testimony, you've constantly stated that there are treaty-based prohibitions. Would you care to elaborate on what treaty prohibitions are you talking about?
So I believe that so there is no explicit ban on the use of thermobaric weapons. However, sorry, please go ahead.
No. Please go ahead.
So certain international treaties like the Convention on Certain Conventional Weapons, the CCW, under Protocol 3, so it can it does prohibit the use of certain incendiary weapons, and certain categories of thermobaric bombs have been known to be incendiary weapons. For example, if I may just cite some of these thermobaric weapons, such as the one that you...
Yes, could you just, because of paucity of time, could you just stick to the questions that have been asked to you?
I'm very sorry. We are interested in listening to that. It might shed some light about the conduct of the accused. Yes, please.
Thank you, Your Excellency. Certain categories of thermobaric bombs, such as the SNAWNE thermobaric rocket and the BLU-118B thermobaric bomb, are some of the thermobaric bombs which are also regarded as incendiary weapons, even though there is a distinction between thermobaric bombs and incendiary weapons. Then further, the Convention on I think cluster munitions can also under international law prohibit the use of thermobaric weapons, because certain thermobaric submunitions can be banned under this convention. Your Excellency, I would request your permission to cite the names of some of these cluster munitions.
I think that is enough for the moment. We've got a general idea of the thrust of...
Thank you, Your Excellency.
Mr. Amboto, since you've been constantly contradicting yourself, I would first like to ask you, how are thermobaric weapons incendiary weapons? On what basis do you state that?
So no, I did not say that all thermobaric weapons are incendiary weapons. I said that certain categories of thermobaric weapons can be regarded as incendiary weapons.
Answer in context with the present case. Does this present case... Sorry?
Your Excellency, may I raise an objection with the permission of the bench? Your Excellency, the counsel for the defense has first of all stated a misleading statement that you have constantly contradicted yourself. And the second thing being, the witness has already deposed before this court that they are not a fact witness, and the defense counsel continues.
The defense counsel is merely...
Please continue my objection. Much obliged. Your Excellency, the second submission being that the expert witness has already deposed that he is not aware in detail about the factual circumstances of the case, and hence he won't be able to assist with his testimony pertaining specially to the facts of this case.
At least from my side, I fully agree with that objection, and it would be inappropriate to say that the witness is lying unless you have proved it, and I don't think you have, and it's a very serious allegation to make. We have to maintain the dignity of the individuals who come here to the court. So I would request you not to make such insinuations unless you have, just like you're submitting evidence beyond reasonable doubt, not just preponderance of probabilities.
Definitely, Your Excellency. Much apologies. The defense counsel was just pointing to the fact that the witness just stated that thermobaric weapons are like incendiary weapons. However, now the witness is stating that only certain thermobaric bombs are like incendiary weapons and some are not. So, which is why we're not understanding the discrepancy, and we would like to ask...
That's how I understood it to be. That's how I understood. That's what the witness was saying, unless my colleagues on the bench saw it otherwise. At least I understood exactly as he was submitting.
Definitely, Your
I think you
Excellency.
should move on, not make an issue, not start a battle which probably you've already lost.
Definitely.
Well, I wouldn't go so far as to say that. So what you're doing, counsel, is pointing out that the expert witness has now made two different statements. One, that all these bombs, some bombs are incendiary, and then he now qualified under your cross-examination that it's certain. All right, so I get the point on why you intervened. So I think that explains, and therefore we don't have to uphold that objection. So where do you go from here with that?
Thank you, Your Excellency. Now the question for the witness is, how does the CCW convention that you mentioned in your testimony apply to the present thermobaric bombs, present case vacuum bombs?
See, whatever kind of vacuum bombs were used in the present case, I'm unaware about, because that's a very factual. I do know that they were prototype vacuum bombs. So would there be a specific category of vacuum bombs you were referring to? For example, would they be cluster munitions? Would they be rocket propelled? Would they be grenade launchers? It's an entirely vast array of thermobaric weapons which are under use.
Okay, witness, moving on. You mentioned that there are harmful effects of these weapons. In your opinion, are these the only weapons having such characteristics?
So the kind, yes, basically the specific physiological and environmental impacts that I did mention, yes, these are the only weapons, basically vacuum bombs, which are a subset of thermobaric bombs. These are the only kind of bombs which can have such impacts.
Sorry, for my clarification, do you mean other thermobaric bombs don't have this impact?
No, Your Excellency, I meant that the specific physiological and environmental impacts that I specifically mentioned are the ones that thermobaric weapons have. They tend to have.
Mr. Ambassador, do you have any scientific evidence or basis to reach this division of these bombs, saying that one will have an impact and other will not have an impact? On what basis you're drawing a difference?
So, Your Excellency, these I had mentioned certain physiological impacts of thermobaric bombs, such as the rupturing of lungs, the deprivation of oxygen. In addition to this, there are other impacts such as the rupturing of tissues. These are only the physiological impacts that vacuum bombs can have. So I believe that there are certain impacts which only vacuum bombs can have. Yes.
But you didn't provide the source which was called for. Sorry, I'm so sorry.
Just a quick question, Mr. Umberto. You mentioned that there is no express prohibition on this particular type of weapons. So I was wondering, in your knowledge, is there any international law provision which prohibits a new weapon which is harmful to victims, as you have mentioned, which can be drawn in this situation?
Your Excellency, I believe that the vacuum bombs which were used in this case were new prototypes. However, vacuum bombs on basis of the available scientific data, the kinds of impacts they can have would certainly fall under certain conventions, such as the Convention on Cluster Munitions or the Convention on Conventional Weapons, etc., as well as the Environmental Modification Treaty, Article 1 and 2.
No, it is not about the N mode which I'm talking about, the general provisions of international humanitarian law or criminal law, as you were mentioning earlier. Is there any provision which directly addresses a situation like this where there is no express prohibition?
Your Excellency, I would have to cross-check that, Your Excellency.
Thank you.
Yeah.
Your Excellencies, that was about it from the Defense Counsel, and the Defense Counsel has made its point with the cross-examination of the present witness.
Thank you.
Your Excellencies, if we may have the permission, the prosecution would like to proceed with the chief examination of prosecution witness 2.
Go ahead, yeah.
Much obliged, Your Excellencies. Your Excellencies, the witness we have here is a fact witness. Prosecution witness 2, could you please turn on your camera? Are you here, prosecution witness 2, Mr. Oliver?
Yes, am I audible?
Yeah, you're audible.
Yeah.
Thank you. Your Excellencies, if we have the permission, can I administer the oath to the witness?
Yes.
Thank you, Your Excellency. Witness, kindly repeat after me. I solemnly declare
I solemnly declare
that what I shall state
that what I shall speak
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, witness. Witness, could you please introduce yourself to the court?
Good afternoon. My name is Oliver Twist. I am the Chief Detective of Emerald City, and I am 43 years old.
Mr. Oliver, how are you related to the present situation in the Emerald City? Could you please tell the court?
Indeed, I have assisted the Office of the Prosecutor in conducting the on-ground investigation relating to the situation in Titan, and I am also one of the senior-most investigators of the country.
Thank you, Mr. Oliver. Mr. Oliver, could you please tell the court how will you assist today?
On the basis of my investigations, I am here to provide insights on the actions of the accused for the purposes of this pretrial hearing. Further, I am here to provide the court the larger context of the war waged by the Republic against Titan.
Mr. Oliver, as you just referred yourself to as an investigator helping ICC prosecutor in Titan, can you please explain the findings of such investigation?
Over the course of the attacks, I worked in close association with the Ministry of Defense of Titan in providing crucial information to NATO forces and other international law enforcement agencies. In my investigation, I found out about the torture chambers that were being operated by the mercenaries of Republic in Titan, the placement of arms and ammunition across the country, as well as the advancement of Republican forces in Titan as per their policy.
Thank you, Mr. Oliver. Mr. Oliver, you just stated about the Republican policy. Could you please explain to the court about the impact of Republican policy?
Yes. The Republican leader, David Wallace, aims to annex all such territories that were previously seceded post the Second World War. The Republican foreign policy was enforced under his presidency and has been to use brute force in regaining lost lands and resources, no matter the human cost of such aspirations. This ruthless policy has been used to devise and implement the attacks against the city of Emerald.
Mr. Prosecutor, are you also trying the accused for the crime of aggression?
No, Your Excellencies.
Then why are we getting into all these discussions?
Your Excellencies, we would like...
You want to prejudice us.
Your Excellencies, we would like to... by this question, the relevance of this question was that the accused had the relevant motive to attack the Titanian population, and this was aligned with the presidency of Republican nation. And
well,
this
would
that
relevant? How is that relevant to the allegations?
Your Excellencies, under Article 82B1, there is an element which says that accused intended to attack the civilian population.
So, are you saying motive? Or you said you want to establish motive, but now
apologies, Your Excellency.
Intention. What is it that you want to do?
Apologies, Your Excellencies. I wanted to say that about the intent and not the motive. I apologize for the same.
But you are giving us the reasons, and reasons mean motive and not intent, because there's a distinction between motive and intention.
Absolutely, Your Excellencies. But currently in our chief, we are establishing a base upon which, in the cross-examination of other witnesses, will build on the same and provide the reasons for the same in the closing statement.
I mean, I get the impression you're going way beyond the charge you have made, because you haven't made a charge of crime of aggression, which you could have because you're the prosecution. But I mean, I would request you to stick to your evidence to the charge and not straddle way too outside. I can understand the context, but not to sort of create a new charge altogether.
Indeed, Your Excellency.
Because I'm a bit disturbed. I heard about torture, and you haven't brought any charge on torture, which is fine. It's your choice, but still.
Indeed, Your Excellencies. May I have the permission to proceed with the next question?
Yes, you may, but just be mindful of what Judge Rajput has put to you. You're dealing with the context. You haven't established whether this witness had anything to do with the investigation of the accused's activities. So go ahead, proceed now. We just draw your attention to these two problems.
Indeed, Your Excellencies. Mr. Oliver, to the best of your knowledge, could you please explain the status of the accused in relation to the furtherance of the Republican policy?
Yes. The accused was chosen as the leader of any strategic operations in the attacks against Emerald City by the Republican government, which shows that they were acting as an extended arm of Mr. David Wallace's presidency. The importance of the accused was crucial in both the planning and the implementation of these strategic attacks to show that he was crucial not only in terms of his knowledge in the key geography of the region, but also in terms of implementing the broader policy.
Mr. Oliver, as you just stated that Emerald City was a key geographical location. Can you explain it to the court how it is so?
Yes. In terms of the Republican annexure of Titan, Emerald City is of strategic significance to the successful implementation of this policy, because it is not only the gateway to one of the largest power plants of the country, but also the headquarters of the Eastern Air Command of the country of Titan. Thus, capturing Emerald City would allow them to cut off the power supply to large areas of the country and also neutralize a significant amount of defense resources available to them. Furthermore, the residents of Emerald City were staunch supporters of the central government's political demand to join the European Union, and which had primarily started from the politicians and parliamentarians of the city itself. In such circumstances, it was important for them to quash the threat of EU dominance, which started from the center, which is that of Emerald City.
Thank you, Mr. Oliver. Mr. Oliver, moving on to the specifics of this attack, can you please specify how did the accused plan such attack on the Emerald City?
Indeed. As you know, the accused led the attacks against the city that were executed. His exposure and clear understanding of not only the advanced ammunition and bombs that were used over the course of executing the attacks, but also in terms of the geography and terrain of the city, were particularly helpful in destroying significant portions of the city. His personal knowledge was then crucial in the successful implementation of these attacks.
Thank you, Mr. Oliver. Your Excellencies, as I see, my time is up. Can I ask one last question, please, if the Excellencies allow?
Yes, go ahead.
Much obliged, Your Excellencies. Mr. Oliver, since you just stated about that the accused intended to attack on the city, could you please explain to the court from what do you gather such intention?
So the accused stood to gain direct access to the power portals and the higher administration of his country if he was successful in annexing the city of Emerald. So his intent was aligned with that of the presidency, and things such as the using of the vacuum bombs allowed that intent to come to fruition. The fact that he used his own knowledge to get this major advantage personally in executing the attacks shows why the attack went and was conducted the way it was.
Thank you, Mr. Oliver. With this, Your Excellencies, the prosecution counsel is completed with the chief examination. Thank you, Your Excellencies.
Your Excellencies, the victim's legal representative seeks permission from the bench to cross-examine prosecution witness number 2.
Yes, go ahead.
Much obliged, Your Excellencies. Mr. Oliver Twist, can you confirm that this sorry,
there's a little echo.
Can you hear me now?
Yeah.
Is it echoing? Okay. Can you confirm that the written communication as per page 18 of the compromise is given by you to the office of the prosecutor and signed?
Yes.
Thank you. Were you present when the accused was taken into custody?
Yes.
When did you take the accused into custody?
Over the course of the attacks that were conducted against Emerald City, a coordinated plan was executed by members in Titan to capture the accused and bring them before justice.
Before you took the accused into custody, were you involved with any investigation against the accused in the previous war happenings?
Yes, over the course of my lengthy career, I have assisted my government, the Ministry of Defense, and as lead detective, conducted numerous investigations over the course of since the start of this issue.
Mr. Twist, can you tell me what the impact of the bombs that were deployed were on the civilians of your city?
As you know, a significant amount of the infrastructure, key resources such as hospitals and schools were destroyed over the course of these attacks, not to mention the significant loss of human life, both civilian and non-civilian.
What evidence did you examine on the effects of the bombs on the dead civilians?
We particularly studied key civilian areas which were providing services to people, or even shelters such as underground bunkers, etc., where the use of these these vacuum bombs in particular had caused significant damage to civilian populations.
What was the outcome of that investigation, Mr. Twist?
The outcome is clear in that a disproportionate amount of non-participating combatants had been killed.
Thank you. Did you examine any evidence of the effects of the bombs on the surviving civilians?
These examinations were made. However, I am not in the position to elaborate on that right now.
Thank you. Did you find any evidence with respect to the mens rea of the accused in relation to attacking civilians?
I'm sorry, do you mean intent of the accused?
Yeah, I mean the intention of the accused.
As I stated previously in my answer, yes, the accused had a significant amount of personal gain in these attacks being successfully completed under the broader policy of the country that he comes from. And in addition to that, he enjoyed a significant amount of autonomy in the planning and execution of these attacks, which he based on his personal knowledge and experience of the terrain and munitions used.
Thank you, witness. The question was what evidence? So was there any documentary, oral evidence, or anybody that you questioned that gave you evidence of the accused's intention in this particular case?
As you know, I assisted the Office of the Prosecutor in conducting on-ground investigations. So a significant amount of real ground evidence that the Office of the Prosecutor is able to provide over the course of these proceedings were assisted by me.
Okay, would it be true to then state that it was Mr. Paul's intention to attack civilians or non-combatants in the present case?
Yes.
No further questions, Your Excellencies.
Thank you.
Your Excellencies, the counsel for the defense would seek permission to cross-examine the witness.
Yes, please proceed.
Mr. Oliver Twist, in your testimony, you have time and again stated that it was the policy of the leader, the ruthless policy of the leader, and under the presidency of Mr. David Wallace, and the implementation of the broad policy was done under the presidency of Mr. David Wallace, and Mr. Paul Anderson was merely an extended arm. So are you saying that Mr. Paul had any ability to act on his own because he was merely following orders?
Indeed, when I say that he was receiving orders from Mr. David Wallace, this was to establish the broader policy under which the accused was assisting the high administration for personal gain, in the sense that the planning and execution of these attacks were significantly based on the autonomy of the accused themselves as the on-ground leader of these attacks being carried out.
So when you say that it was the policy of the presidency and of the Republican to regroup Titan, how are you coming to the conclusion that it was the personal gain, that capturing of Emerald City would be a personal gain to the accused? How are you coming to this determination?
Being successful in the attacks against the most significant stronghold in the country, being the youngest commander to help the movement of the country, would obviously curry favors with Mr. David Wallace from a military standpoint.
So your whole testimony rests on the belief that the sole motive of the attack on Emerald City was its geographical importance. So are you completely dismissing the fact that it was your government that attacked on our base camp first? in the same city of Emerald?
I'm sorry, I'm not in a position to answer any defense on behalf of my government. I was merely the lead detective assisting with the investigations against the accused.
No worries. Witness.
There is an objection. I think it's.
Your Excellencies, I was raising an objection, but the witness had clarified the same, and I did not want to interrupt the flow. I apologize for not lowering the hand.
Mr. Witness, in your deposition, you mentioned that David Wallace is a psychotic ruler. What do you mean by this?
Any ruler who wants to capture a democratic nation just because they want to join the European Union can, I think, be termed psychotic.
Do you agree that David Wallace would not stop his actions until he regrouped with the Titan?
Yes.
So do you mean to say that he was ready to use all force necessary?
Yes, the leader of which would be the accused before the present case.
Do you also agree that Mr. David had a brilliant capacity to influence other people into following his own agenda?
I'm sorry, I don't know Mr. David.
The president.
Yes, I don't know the president of the republic.
However, you just stated in your testimony that he's a psychotic ruler. When asked, I'm
very sorry to interject. I think the answers have been quite comprehensive. You may move to the next question.
Definitely, Your Excellency. So, witness, would you be competent to answer if Mr. David, the president, had a brilliant capacity to influence other people into following his own agenda?
I think Mr. David Wallace's intention to capture my country and kill my people is more significant in terms of my answers rather than his ability to charm people into doing what he wants.
Okay. You state that Paul Anderson chose to head the attack. Would you say that he had an option to refuse the president's orders?
I think the answer would be, would he want to refuse the president's orders, given that he would have possibly reached the highest tranches of his military if he would have succeeded in executing?
Mr. Witness, could you please just stick to the question that is being asked to you?
I'm sorry, I cannot speculate on the kind of benefits that he perceived at the time of executing these attacks.
So in your testimony, you state that the people of Emerald City would provide serious resistance and pushback to the Republicans. So are you saying that the people of Titan were ready to do anything for the government of Titan?
I think they were ready to do anything to protect their houses and livelihood rather than for their government, which was at a time of the attacks, as you must know, a significant amount of refugee outflow from the country, people feeling unsafe, their everyday livelihoods disrupted, was a time where they would obviously have to come together just in terms of mutual safety and civil support.
So for their personal safety, would they also be willing to, I'm sorry, Your Excellency, I think I'm facing an internet issue. Can I be audible?
We can hear you.
So when you're saying that they, for the personal gain and for personal safety, they were ready to do anything, do you mean that they were ready to act as the eyes and ears of the government?
I'm not sure what eyes and ears of the government would mean. I think it's a common phrase that would be used in any, to try and give some sort of moral support to the people at the time that they're facing military attacks on their homes. But if you're referring to a sort of mutual vigilance that they want, like the government was incentivizing amongst their people in a situation where they could not, give a lot of protection to them. A public safety announcement saying, please be our eyes and ears could be defended, yes.
Point to be noted, Your Excellencies. Would you also clarify how providing information on the Republic militants' locations was for personal safety of the people of Titan?
Your Excellency, may I raise an objection?
I'm sorry, I think there's an objection.
Your Excellency, may I proceed?
Yes, you may raise your objection.
Your Excellency, the witness has not established that Please mute the same. Your Excellency, the defense counsel is leading the witness into admitting statements which he has not stated either in his testimony or in his chief.
Your Excellency, but you clarified that in cross-examinations we're allowed to use leading questions.
If I could answer the question in any case.
If I may say, there was no need for an interruption, because I think your witness was already doing the fantastic carnage, but which we all were enjoying. I think we should let the witness speak. And madam, if you don't have any substantial questions, you can close the cross-examination as well. It can allow us to use time for more fruitful purposes.
Definitely, Your Excellencies. This was my last question, if the witness is capable of answering.
I think there's a difference between being the eyes and ears of the military and being the eyes and ears of the government. In that, as detective, I am the police officer of the country and I have to give support to my people. So them using social media to alert me and say, a man with a gun is standing outside my house, allows me to send some police officers to go help them out. I don't necessarily think this was a coordinated plan by the civilians to help the military of Titan, get strategic military information on their whereabouts.
That's about it from this witness. Thank you so much.
Thank you.
One question, please, Mr. Twist. Did you take the statement of Paul Anderson?
Indeed, we did, ma'am. I was responsible in the coordinated capture of Mr. Paul Anderson at the time of the attacks in Emerald City. Over the course of which we conducted an internal investigation, and our government then decided to hand over Mr. Paul Anderson to the halls of the International Criminal Court to bring them to justice.
I was focusing on the statement. Was that made before you? His statement.
Ma'am, the statement filed in the before this court was taken before the prosecutor themselves, but on-ground investigations was what I was directly involved in.
Thank you.
Thank you.
If I may ask you a quick question, Mr. Twist. You give substantial evidence about intention, but I was curious, did you have any direct knowledge about the accused involvement in dropping of the bombs and ordering its dropping?
Yes.
What is the source of your knowledge?
As you know, a significant amount of military support from our Ministry of Defense at the time of them trying to defend the city I was also privy to that information. Through this military intelligence, we were able to ascertain the fact that the accused was the lead executor of these attacks.
And were you hurt in any manner in these attacks?
No, thankfully not, Your Excellency.
I have one question, Mr. Oliver Twist.
Yes.
You said you have vast experience as a prosecutor and you assisted and you personally investigated the facts of this case. I have one question as an expert and the factual expert. If any person who is in the position of Mr. Anderson will have any option to have any other step to be taken other than the instructions that have been given by his superiors or his authorities above him. Because you repeatedly said about the personal gain of Mr. Anderson and he did it with intention. That's what you spoke repeatedly, if I'm right in understanding you. Under these circumstances, on what basis you can say that it is his intentional act? He could have had another option to follow, but he avoided that and chose to drop bombs and cause the casualty.
Indeed, Your Excellency. Thank you for your question. I think the difference stems from the kind of orders that the accused has received. There would be a difference between a well-planned and strategically executed military attack that came from a designated high command versus the eccentric leader of an authoritarian nation who is merely saying, bring me Emerald City, I want you to capture it for me. The difference between the two meant that in the latter, which the accused was operating under, he was able to use a significant amount of autonomy, decide how, when, and with whom to conduct these attacks, and also the kind of ammunitions and bombs to use. So a large amount of the disproportionality that has been discussed before you would be the personal liability of the accused, rather than just a clear order as to a step-by-step process that a military soldier has to execute. Thank you.
Mr. Twist, you made a deposition that residents of Emerald is ready to do anything to help the government, right? So Does that include taking up of arms? Have you come to any of those level of evidence?
Your Excellency, I'm not aware of the extent to which civilians are protecting themselves or willing to contribute towards the defense of the country. A few of them may have taken up arms. But as per the facts and as far as my awareness goes, I don't think these arms came, as a coordinated plan to bring in the civilians into this effort.
So you mean to say that there was direct participation of hostilities from the side of residents?
Your Excellency, I'm not exactly aware. Maybe as a generalization, I would say vigilantes are seen in most situations of crisis. But on a very broad scale, I think these people were mostly just trying to protect themselves and be safe.
Thank you.
Thank you.
If I may, I find it a bit evasive because you are an intelligence chief. You ought to have some more information about how your nationals were responding. Well, you may not have, but I think it would be a genuine expectation. So if you do have some information, do share it with us.
Your Excellency, at this point, as far as my knowledge goes, with respect to the question of civilians taking up arms, unfortunately, I do not have information on that. But broadly, I think I have established before this court everything that I know of how the civilians assisted us.
All right, since you just used the language civilians assisted us, does that equate to direct participation in the hostilities?
No, ma'am. I was referring to my point about how we were trying to render protective services as the police and not the military to the civilians. So an example of that would be, us encouraging them to use social media to reach out to us and say, military forces are outside my house, please help me. And we would go and, provide some services there.
Thank you.
Thank you.
Defense counsel, have you completed your cross-examination?
Yes, Your Excellencies.
All right, let's move on then. Thank you.
Your Excellencies, the Council seeks permission to conduct the examination in chief of the victim witness 1, who is an expert witness.
Yes.
Much obliged, Your Excellencies. Victim witness 1, am I audible?
Yes, you're audible.
Thank you, witness. Your Excellencies, with your permission, I would like to administer the oath for the victim witness 1, Your Excellencies.
Go ahead.
Witness, please repeat after me. I solemnly declare.
I solemnly declare
That I will speak the truth.
that I will speak the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Thank you, witness. Witness, we are really sorry for everything you have been through. And thank you for coming here today to testify in the interest of justice. Witness, if you're okay, can I proceed to the first question?
Yes.
Witness, kindly state your age, occupation for the benefit of the court.
I'm a citizen of Titan. My age is 47. And my occupation, I am a PhD scholar from the Central University of Titan.
Thank you, witness. Witness, please state to the court your purpose for attending such a trial.
I have been a victim and a witness to the deployments of the vacuum bombs in Emerald City by the Republic. In addition to that, my background is that I am a researcher and consultant in the field of modern warfare, arms and ammunitions. I currently have 25 years of experience in the background of weaponry-based technological processes and combustion.
Thank you, witness, for the answer. Witness, please state for the benefit of the court your expert opinion on the effect of thermobaric weapons.
So for thermobaric weapons, they deploy in two stages. One is where the fuel is released, and this fuel seeks to the crevices and cracks of buildings, soil, safe havens such as caves and bunkers. The second phase is the detonation, where since the fuel reaches a wide area, the detonation impacts, a huge combustion occurs, and this creates severe harm to the people within that radius, which can obviously lead to vaporization of the human beings in that radius. Even if you're not in that radius, you severe various consequences to your life. Your internal organs are damaged. You face pulmonary, respiratory damages, as well as collapsed lungs.
I'm sorry, Mr. Prosecution Lawyer. Is this a witness of fact or witness of opinion? It's an expert witness.
Your Excellency, this is an expert witness, and as well as the witness present here is also a victim in the present case, Your Excellency.
Is there any practice to any precedent to say that a victim can also appear as expert witness?
Your Excellency, witness. This is a witness of opinion in the present case, Your Excellencies.
Well, that's what I'm saying. I'm a bit perplexed. I mean, is it going to be there's somebody who has an interest in the dispute. I can understand being a victim and being a witness of fact and telling all the horrible things one had to undergo. And then asking the same person to give opinions about some scientific issues. If you have any precedent, you can give us some precedent, and I will shut up and accept whatever you say.
Your Excellency, Article 68, Clause 3 mentions that participation of the victims in the present case as witnesses.
68 Clause 3 of the statute
of the Rome Statute.
Evidence. Yes, 68.
No, Rome Statute.
Could you read it out for us? Yeah. What does it say? Could you read it out for us?
5,
7, 8. Yeah.
Your Excellencies, may I?
Well, yeah. Yes, please. Yeah.
Your Excellencies, when the personal interests of the victims are affected, the court shall permit the views and concerns to be presented and considered at stages of the proceedings determined to be appropriate by the court in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. Such views and concerns may be presented by the legal representatives of the victims where the court considers as appropriate in accordance with the rules of procedures and evidence, Your Excellency.
Yeah, so we have the discretion to decide if it is. Yes, please.
Your Excellencies, also in the case of the prosecutor versus Lubanga, which was also the first case to be tried by the International Criminal Court, the victims were allowed to participate in the proceedings as witnesses, Your Excellencies.
Let's be clear again. There's no objection to victims participating as witnesses of fact. There's no doubt about it. The question is, can they express opinions? And did the court say in Lubanga that they can go ahead and make some observations about technical scientific issues involved in the trial?
Your Excellencies, as far as the opinions are impartial in their nature, and if they hold scientific, if they have evidentiary value as well, they can be accepted in the court, Your Excellencies.
Scientific evidentiary value, how are we going to judge? You need to understand, when we have a scientific evidence, we know nothing about the area and we have to blindly trust the witness. And then you're asking us to also do the check the veracity. And we can't check the veracity of an opinion witness. We can only check the veracity of the factual witness.
Apology, Your Excellencies. If the opinions given by the witness is holds the same value as the other evidentiary evidentiary value of the presented in the case, Your Excellencies. And in the present case, the witness is also a highly qualified candidate in the present case.
Well, maybe with due respect to the witness, but it's a different capacity and a different situation. So I find it very uncomfortable. I'm just setting it right at the beginning. You may certainly proceed and exhaust your time, but I still don't feel very convinced that a victim can then step out as an expert on technical issues and also give technical evidence. But you may proceed.
Much obliged, Your Excellencies. Witness? Am I audible?
Yes, you're audible.
Witness, could you state the events that happened from October 22nd to 25th in Emerald City?
Yes, so there was a deployment of vacuum bombs by the Republic onto Emerald City. This caused catastrophic damage. It not just affected the lives of the humans, but it also affected the buildings around it, the safe havens, bunkers, all such buildings, they were collapsed. There was not just one area which was targeted, there was a large area around which was completely destroyed by the bomb.
Thank you so much, witness. Your Excellencies, that's all for the chief in examination.
Just one question.
Yes.
To you, victim witness, is you've described the destruction to infrastructure and so on. Are you in a position to talk about any injuries or death of people as a result of these bombs?
So I have been a witness to the deaths that have occurred because I was there during that time. Although I did not suffer any major physical injuries, I have witnessed these, the life being taken away from around me.
Thank you.
Madam Witness, if I may ask, Doctor, you said that you saw there were these vacuum bombs dropped. I mean, you identified them when they were dropped, or you determined it eventually that based or for some other reason?
So due to my expertise and the background that I have with weaponry, weapon-based technology, I was able to determine due to the characteristics of the bomb that it was a vacuum bomb. Thank you. No.
All right, let's proceed further.
Your Excellencies, may the counsel for the prosecution begin with the cross-examination. Much obliged. Mr. Witness, since your name is redacted, could we just refer to you as VW1 or witness?
Yes, you may.
Thank you so much, and thank you so much for coming today. And just to establish the scope of your testimony, can you state your fields of expertise and how you will be able to assist the court?
Yes, I am a researcher and consultant in the field of modern warfare. I do have a PhD scholar from the Central University. My thesis was on the effects of the vacuum thermobaric bombs on humans as well as the tangible assets. I have been I have 25 years of experience in the background of weapon-based technologies.
Thank you, witness. And so it is correct to safely conclude that you're a witness in your field, that you're an expert in your field. But since in your previous testimony, you've offered statements with regarding the factual circumstances of the same, so are you aware of them in detail to offer your testimony, or should we limit our questions to your scientific expertise?
You may limit them to the scientific discoveries, as I'm not a factual witness within the case.
Thank you, witness. Witness, could you please mention, could you please mention the pain and suffering, or rather the harm the victims suffer with the use of these bombs?
Yes, so the damage which occurs to these victims is extremely severe. If you're in the blast zone of this weapon, then you are automatically vaporized due to the negative pressure that the bomb creates. Now, even if you're not in that blast zone, you can have a lot of severe consequences. These include collapsed lungs. You can have...
Your Excellencies, is it only for me, or is the video of the VW1 call?
It's for everyone, it seems.
Could the Chamber Master please look into it and confirm?
While it is coming up, I have a question, Mr. Prosecutor. Are you presenting this evidence to corroborate the evidence? Because we have already heard another expert on all these factual issues, these technical issues.
Indeed, Your Excellency, the relevance of the same was to just ascertain the scope of their testimony, and the relevance for this question was to lead up with the two following questions with regarding the harm exceeding the target area, as the witness had just mentioned, and I was going to proceed forward with.
Which is fine.
Witness, can you hear me now?
Yes, I can.
Thank you. Witness, since you just mentioned that the harmful effects, such as on the lungs and the pulmonary system, can exceed the target area, is that correct, right?
Yes, it can.
The harmful effects, in simple language, the harmful effects of the same can go beyond the target area.
Yes, they can.
Thank you, witness. And in your testimony, you mentioned neutralize the fertility of the soil. So could you elaborate on the same?
Yes, so during my PhD, I did research in the Second World War, Vietnam, and finally Afghanistan. And through this research, I was able to find that these bombs not only affect the buildings, but they affect the soil as well. And it leaves impacting effects on the soil, infertility.
So witness, by neutralize, you mean that for a long term, for a longer or an irreparable period of time, the fertility of the soil is eroded and finished?
Yes, exactly.
Thank you, witness. And you had mentioned that you state your opinion in your last paragraph regarding the legality of these bombs. Could you care to elaborate the reasons for the same?
Yes, so based on the observations that I have made, and I find that these weapons are inherently indiscriminate and disproportionate, and they are without a doubt banned in the existing preemptory norms of law.
Could it be said that the reason?
Counsel, I'm so sorry. I know we're getting into this issue of expertise quite a bit. Are you presenting? Are you utilizing this witness as a legal expert?
No,
because I noticed you ask questions about legality.
Oh, Your Excellencies. Excellencies, since my time is up, may I seek 1 minute extension to conclude this line of questioning and answer your question?
With the presiding judge's permission, yes, please go ahead.
Your Excellency, it is not that the witness is being presented as an international law or an independent international law expert, but since their field of expertise is in the weaponry-based technology and they've been working as a PhD scholar, they may be able to offer their opinion with their legal opinion regarding to their limited field of expertise, not as a general legal expert, but limited to the scope of their expertise.
But can they make a determination that something is violation of a peremptory norm of international law? Because I'm sure many international lawyers are still struggling. What is a peremptory norm of international law? Your
Excellency, as it is my understanding that since the witness has mentioned the widespread long-term severe impact on the environment and the extreme pain suffering, and that the harm can go beyond the target area itself, it might be that the witness is aware of the general principles, and since they have mentioned the disproportionality and inherent discriminate use of these weapons, considering their expertise in the same area regarding their study and their use and effects.
Can I clarify the question by Your Honor?
Yes, please. I think that's very important. Please go ahead.
Yes. So when I mentioned the preemptory norms of law, I am aware of the Geneva Conventions, which are there against using weapons against civilians. So I am aware of this convention, and that's why I stated that they were against preemptory norms of law. That is, from my opinion, what I base it off of.
Very good. Are you also aware of what are the elements to establish peremptory norms of international law?
I am not aware into extensive details. I am simply aware of the Geneva Convention that these weapons it actively bans the weapons being used against civilians, and that is what occurred in this situation. In my opinion.
But that's from a technical expertise, not from a legal expertise. That's for us to decide, isn't it? Whether
yes,
the
it is
being breached or not.
Yes.
And whether there is even a peremptory norm saying that violation of one of these conventions constitutes a peremptory norm. That's for us to decide, isn't it?
Yes, it is. Absolutely.
Thank you.
Your Excellency, since I've exceeded my time, I would like to conclude my cross-examination of VWI. Much obliged.
Your Excellencies, with your permission, the Counsel for the Defense would like to start its cross-examination.
Yes.
Witness, the first question that I have for you is that when the Excellencies asked you whether you could identify the bombs as and when they were being dropped, to which you stated in the affirmative, but the bomb that was used in the...
No. I did not state that I was able to identify it then and there. I was able to determine over time, seeing the impact of it later on, that it was clearly a vacuum bomb. I did not determine it there and then. It was in the course of seeing the nature of the bomb.
Okay, moving on. You mentioned that you mentioned that they have used in Afghanistan. So are you also aware that the use was justified in the case of Afghanistan?
I'm aware that the geographical locations of Afghanistan are very different from Emerald City. And that is why it was justified in their case, because they have mountainous...
a similar situation of the use of intel by the...
I'm so sorry. Could you just allow the witness to complete the sentence?
I'm so sorry. My apologies, Excellency.
Could you please complete, madam?
Yes, so in Afghanistan, the geographical location is much different to Emerald City. If you see, Afghanistan has mountainous regions, and that is why they determined that vacuum bomb was the ideal circumstance of using it. However, if you check Annexure 1, I believe page 31, you can see the map of Titan and Emerald City. There are no geographical indications of any mountainous regions, and hence it is not justifiable to use a vacuum bomb in this situation as compared to Afghanistan.
Definitely, we understand about the geographical locations. However, the question here is about the providing of intel, the providing of information on military, which is why the use of vacuum bombs was justified in the case of Afghanistan.
I am not aware of this intel. I cannot speak onto that. I'm providing what I know about Afghanistan's geography compared to Emerald City, which it is not justified.
So are you stating that you're providing incomplete information about the case study of Afghanistan and how their use was justified?
No, I am providing to you.
Objection, Your Excellency, is argumentative. The victim is able to explain geographical location, which is what they've testified in their written submissions. The council hasn't explained why they're asking about intel in Afghanistan, and none of it is in the written testimony.
Your Excellencies, it is the same case.
I think you should move on, defense.
Much obliged, Your Excellencies. What evidence witness do you rely upon to state that advanced countries have launched countless socio-legal movements against the use of vacuum bombs?
So when I stated about the socio-legal movements, I can give you an example of the Cluster Munition Coalition. It is a civil society movement which campaigns against the use of production of stockpiling and usage of cluster munitions. That may be one example of a socio-legal movement that I have stated.
Witness, if I might, the present case deals with the use of thermobaric weapons. So could you state with reference to that?
Yes, so the Cluster Munition Coalition, it involves thermobaric weapons as well. That is a movement which is advocated against the use of cluster munitions.
Witness, you mentioned that you mentioned about the Geneva Convention. So does the Geneva Convention ban the use of the weapons used in the present case?
I am not aware if they have directly banned it. I am aware of the fact that they actively ban against these the use of this weapon against civilians. And that is why I determined that it was, that's why I thought, in my opinion, it would be against preemptory norms.
Witness, why do you call vacuum bombs indiscriminate?
They're indiscriminate because you cannot limit the extent of which they go through. Like, you cannot limit the radius. The fuel spreads across and it goes into cracks in the crevices and it goes into bunkers and buildings. You cannot control where it ends up going when you detonate it. So it's indiscriminate in that sense. There is no way of controlling or targeting any specific region.
Your Excellencies, I see that my time is up, so I would like to conclude the cross-examination.
Thank you.
Your Excellencies, if I may.
Yes.
Your Excellency, witness speaker one, victim speaker one.
Yes.
Your Excellency, with your permission, if I may make up a submission based on the related to the victim witness one, Your Excellency.
Well, let me get some guidance from my colleagues here. Is this the time to make the submissions or at the end of the proceeding?
I suggest at the end, isn't it?
Much obliged, Your Excellencies.
Is that what others on the bench also agree with?
I imagine if these are substantive submissions on the facts, they're more appropriate for the closing submissions.
Much obliged, Your Excellencies.
Okay, thank you.
I agree.
Your Excellencies, the Council seeks permission to conduct the examination in chief of the victim witness 2.
Thank you. Go ahead.
Much obliged, Your Excellencies. Victim witness 2, am I audible?
Yeah.
Your Excellencies, with your permission, I would like to administer the oath.
Yes, you may, but we don't have a picture of the victim witness 2.
Your Excellency, the victim witness 2
Am I clearly visible and audible? Yes.
All right. Thank
Your
you.
Excellency, may I?
Yes, please go ahead.
Much obliged, Your Excellencies. Witness, please repeat after me. I solemnly declare
I solemnly declare
that I will speak the truth,
that I will speak the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, witness, for being here today, despite all that you have recently been put through. We really empathize with your interest and shall strive to make your case to the Honorable Chamber. Witness, with your first question, kindly state your name, age, and occupation for the benefit of the court.
My name is Pavel Vlasov. I am 26 years old. I am a Titanian by nationality. My occupation is that I'm a field journalist.
Thank you, witness. Witness, please state to the court your purpose for attending such a trial today.
Well, as stated, I am a field journalist and a civilian who was working at a network station of Emerald City during the period of conflict. During the time of conflict, I used my own open access social media handles to alert and safeguard the people of my city from the danger that seemingly faced them. I'm also a victim of this war, and I lost people of my own, and I wanted to do my part as little as I could in safeguarding them. So as a result, I was posting news as per not only my journalistic duty, but my moral duty, and spread awareness about the crimes which were being perpetrated against my people who were innocent civilians. However, much to my surprise, I was recognized as a combatant by the pre-trial chamber.
Thank you, witness. Witness, as you mentioned, please elaborate as to the usage of social media throughout the war between Titan and Republic.
Yes, well, social media is used all across the world, and my people were no different in this situation. The war was an event, one of far greater consequence than all other cumulative events we're tweeting about. And as a result, there's no wonder that people use their phones to capture the invasion of the Republican Army in good faith. And we have suffered enough, and the impact of this war will continue to haunt generations of the Titanian population. And I think all others like me were just trying to safeguard the people we loved, and we had seen enough loss and suffering, and therefore we were trying to do our bit.
Thank you, witness. Witness, would you elaborate on those attacks that was caused due to the thermobaric bombs?
Well, they were quite horrifying in nature. I mean, when something of this nature does occur, it does tend to shake up the entire population, especially a city like Emerald. There were attacks which were being carried out one after the other, and the people were in a state of panic and worry. And of course, there was a lot of frantic energy everywhere. And as a result, the people of the city were just trying to safeguard themselves, and protect their loved ones. And being a journalist, someone who wanted to be a journalist since I was a child, I was just fulfilling my duty and trying to save as many people as I possibly could from the pain of something this horrifying in nature.
Thank you, witness. Your Excellencies, that's all for the examination in chief.
Thank you.
Your Excellencies, may I begin with my cross-examination of VW2?
Yes, is that prosecution?
Yes, Your Excellency.
Yes, all right.
Good evening, Mr. Vlasov. How are you?
I'm great. Thank you so much.
Mr. Vlasov, as you've mentioned in your testimony, the reasons for using social media, right?
Yes.
It is correct that it is natural, in general, it is natural to inform other persons around us about our circumstances and situations, as you mentioned that the war was an event.
Of course it is. I think apps like TikTok, Twitter, Instagram, and all other social media handles have, at this point in time, become a global trend. And I think youngsters or even elders alike use them to subconsciously gain validation and the dopamine rush by trading, of course, your personal and private data. So I don't think it comes to any surprise that when something as large of an event as a war and an attack on these people was being faced by them, they took to social media to warn others and also warn, of the crimes which are being perpetrated against these innocent civilians who were under attack. So I think it's a very common phenomena for social media to be used.
Thank you, Mr. Vlasov. And I would request that since you've stated most of these things in your examination chief, just answer the question to the precise point.
All right.
Thank you, Mr. Vlasov. So, Mr. Vlasov, considering your justification, And is it a reasonable inference that with the war being a very big event being undertaken, there would be, or there is a possibility of an increase in social media usage?
Yes, definitely.
Thank you, Mr. Vlasov. And Mr. Vlasov, as you mentioned your actions to undertake the posting in the last portion of your testimony, could you in brief elaborate the reasons for the same?
Yes, well, as I stated earlier, I am a journalist by nature. And when there was an event such as an attack on my city, which was taking place, I did feel the need to inform my people, inform the citizens of the dangers which were being faced. But then again, I would like to state that my actions were undertaken in my capacity, motivated by my incentives, and were divorced from any collective strategy or goal of titanium.
So it is correct, as you had stated, that the persons and you were not acting as cohorts or compelled by the government?
Definitely not.
Thank you, Mr. Vlasov. Mr. Vlasov, are you aware in detail about the factual circumstances of the case?
To my limited ability of what I saw as a field journalist, yes.
Your Excellencies, for the benefit of this court, may I read out a statement from the annexure which I am referring to establish the relevance and context? Your Excellencies, I am referring to page number 39, annexure number 4, paragraph number 2. Read out the statement for context, not asking the witness to corroborate the same. May I read it out?
Yes, I mean it's on the record and we have read it. I'm not sure unless you want to highlight something from there. It's too long a paragraph to read.
Just one line I would like to read out.
Yes.
People hiding in another bunker located some 7 kilometers away from our location had tipped us about the movement of their troops with heavy artillery. We were prepared to duck and remain voiceless and motionless in our position inside. Witness, having heard this, would you agree that this is consistent to your testimony that it was done for the safety of the persons and their known and their mutuals known persons?
Yes, definitely. Like I stated, social media in now's day and time is a very powerful tool. And I think my citizens and my people were trying to use this to the best of their ability to safeguard not just themselves, but others as well.
Thank you so much, Mr. Vlasov. You've assisted the course in the utmost manner possible. With this, the Counsel for Prosecution would like to conclude with their cross-examination. Much obliged, Your Excellencies.
Your Excellencies, the Counsel for the Defense would like to request permission to cross-examine.
Yes, go ahead. I just want to report that my screen has gone blank, but I still have the audio. So I don't know whether the problem is at my end or yours. Can you hear me?
Yes.
Yeah.
All right.
We
Thank
can
you.
both
All right.
hear and see you. Yes.
Yeah, all right. Defense Counsel, go ahead then.
Okay. Much obliged, Your Excellencies. Witness, you stated that your occupation as a journalist was working for the state-owned local network station. Is that right?
Correct. Yes.
You also stated, it was also stated that the command for acting as the eyes and ears were through multiple televised events on television.
Yes.
So are you saying that you were not aware of the televised events and you chose to refuse the orders of the government and you were doing your job?
But here I'd like to clarify that there were no orders of the government which were given to me or any of the other citizens or non-combatants specifically. Like I also stated in my statement previously that my actions were undertaken in my capacity and motivated by my own incentives. And as a result of the same, I was using my own personal open access social media handles to spread this news of the attacks. And it was in no way directed or directed by the government itself. I had no contact with them, of course.
But the facts clearly state that there were directives issued.
I would also like to state very clearly over there that the directives were not issued with respect to indicating what the action of the Republican Army would be. The directives were to make sure that there was safety which was there. And that's exactly what me and others alike were trying to perpetrate. We were trying to ensure that not only us, but our loved ones, our family, the children in our town, and everybody was as safe as they could possibly be.
Witness, if I could just interrupt. The directive was to act as the eyes and ears. However, I would like to move on due to the paucity of the time. Did you know that the postings that you were making led to 3 successful airstrikes?
Absolutely not. I had no awareness of the same.
So are you saying that the first time you made a post and it was successful, you weren't aware, you did not pay any attention, but you attempted to make the second post, and the second time as well, you had no information that it was happening according to you. However, you were following the entire warfare, entire armed conflict. You were aware of everything, but you were just not aware of what was the consequence of your posting for 3 consecutive times.
Firstly, I would like to clarify that I was not aware of all warfare and all incidents and occurrences which were.
You're a journalist.
Sorry, apologies. But even at that time, I did very clearly state in my statement as well as my testimony that all the journalistic reporting that I was doing was in my own personal capacity and not related to my employment at all. There was a state of panic, there was a state of war, and I was trying to report as much as I could as a field journalist in the area where I was present. And as a result of the same, I had no awareness that there were any actions being taken on part of my post. Yes, of course, I'm a journalist and I am some sort of a well-known person in my town, but that doesn't indicate that the posts were being made specifically for my government, as stated, but for the security and safety of my people.
You are constantly stating that you were acting on your own personal capacity. However, you were employed by a state-owned media channel. So are you saying that you were not doing your job, but you were doing your job?
I was doing the job in my own moral capacity. Yes, I think that's it.
Moving on, you stated in your... Moving on, you stated in a...
I would like to complete the question. I thought there was an interruption. Someone was trying to raise an objection.
No. We have another question. You stated in your testimony that your use of social media was a welcome consequence of your actions. So were you happy about the results that were coming about from the posting of your social media?
The welcome consequence of my actions was that I tried to save the lives of as many people as possible. And I hope that I was successful in that aim, because my welcome consequence was warning the people of my town, my loved ones, to be safe and be aware of what possible attacks they may be subjected to. And that was the welcome consequence, saving as many lives as possible.
However, your testimony states that however, it was stated that a direct consequence of your posting was the successful airstrikes. However, moving on, just my last question because my time is up. You state that there is a dopamine rush that people get from posting on social media. What dopamine rush were you getting by posting exact locations of the armed forces?
Like I stated,
Excellencies asked and answered. The witness has already testified. A lot of this is because they wanted to keep their civilians safe.
Well, witness, do you have a response to that question?
Yes, ma'am, I may provide a response to that question. Firstly, my testimony where it's talking about dopamine rush very specifically talks about the general population and worldwide while social media is used. It was in no way a reference to why I was using social media. But yes, if I'm talking about it in a personal capacity, like stated earlier, it was my duty and obligation to inform as many people around me to save them and safeguard them from these attacks. And that's exactly why I use social media in the first place as well.
Any further questions, defense?
Your Excellency, just one last question. You mentioned that the first instinct you have when you see a crime is to record it. But when you see an army of soldiers coming at you with guns, is your first instinct to take out your phone and record it, or to save your life?
I'm very sorry. I'm very sorry, madam. How is this question relevant? It's a question of opinion. You're making insinuations one after another. You made it in the last question as well. I didn't interrupt because I wanted to save time. I don't think I'm going to allow any such insinuations and questions, at least on my
part. With that, the defense counsel would like to excuse the witness.
Thank you.
Thank you.
With Your Excellency's permission, I would like to call defense witness 1 to the stand for chief examination.
Yes.
Witness, can you make sure that you're audible and visible to court?
Yes.
Okay. For the record of the court, please state your name, nationality, and age.
My name is Dr. Michael Sugre. I'm a citizen of United States of America, and I'm 57 years old.
Could you please give an account of your experience and expertise and years of practice?
Sure. I'm a former professor of the Applied Mechanics Virginia Military Institute. I'm a trained mechanical engineer and design expert, and I have been teaching and developing advanced weapons in Virginia for the US military for 20 years.
Witness, what is your take on the legality of weapons, especially thermobaric weapons with respect to international law?
So my testimony stems from the fact that there are no international legal instruments which prohibit the use of these weapons. Secondly, the objective of military necessity and the incapacitation of military targets of sufficient importance negates the assumption that these weapons cause superfluous injury and are inherently indiscriminate.
Thank you, witness. My next question to you would be, you have stated in your testimony that these weapons are not inherently indiscriminate. What is your understanding of an inherently indiscriminate weapon?
Sorry to interrupt the counsel. You said you are a mechanical engineer, and how do you claim legal expertise being a mechanical engineer? Would you like to clarify? I have a doubt, because a mechanical engineer, how can he speak about the legality of the issue? I'm sorry, that's what thank you.
Sure, sir. Since I'm a trained mechanical engineer and design expert, but I've also been teaching and developing the advanced weapons for the US military, I do have insights into the legality aspect in relation to these weapons which have been developed.
Okay, but as such, you don't have any legal expertise. Am I right in understanding or presuming that?
Yes, sir. So it's limited to the weapons I've been like developing and teaching about.
Thank you.
Much obliged, Your Excellency. Witness, do you want me to repeat the question, or could you continue?
No, I'll go ahead. So as far as my knowledge goes, inherently indiscriminate weapons are basically those which do not distinguish between civilians and combatants. During my PhD, I did come across a particular example of such weapons in terms of inherently indiscriminate weapons as incendiary bombs, which were tied around the necks of bats and then released over enemy targets.
Noted. Witness, what evidence do you rely upon to state that thermobaric weapons are not inherently indiscriminate?
So before branding a weapon as inherently indiscriminate, we need to consider a wide range of circumstances in which these weapons can be lawfully used. You cannot say that there's absolute certainty that every use of thermobaric bombs would destroy in a large indiscriminate manner. Moreover, we also know that the brutal catastrophic effects of nuclear weapons are such that they wipe out the entire civilization and ecosystem. Despite having these efforts, they were ruled as not being inherently indiscriminate, and the thermobaric weapons cannot be by any means be compared to a nuclear weapon.
Noted, witness. My next question to you is, how are thermobaric weapons different from incendiary weapons, and why is that distinction relevant to us?
So when we look at incendiary weapons, their primary aim is to cause burn injuries or to set fire to objects, whereas thermobaric weapons are designed to create blast and pressure, and the burns are only an incidental part to it. The distinction may be relevant because there's an attempt to bring thermobaric weapons under the umbrella of incendiary weapons so far as to constitute them as being prohibited would be illegal. And the relevance to this is that there is no international legal instrument that explicitly prohibits these weapons.
Noted, witness. My next question to you would be that, did you mention that advanced countries have omitted any prohibition on these weapons? Which advanced countries are you referring to here?
Since I'm a national of USA, I can vouch for USA being one of them, and even Russia, given the fact that these are the two countries that have made most of the recent use of thermobaric weapons. And it's also that US used it in 2017 in the Afghanistan case study, which is mentioned, and it's also alleged to have been used in the Russia-Ukraine war.
Noted. You stated in your deposition that that, as you mentioned, that you did this studied the Afghanistan case, and you stated in a deposition that a similar application of the Afghanistan case is applicable here. What do you mean by that?
So I basically meant that the part regarding the execution of the farming community because of them leaking and intel justified their killings. And that part is the part I wanted to bring about in the applicability in the present case. The part about the mountain topography is just something that I remember from the research, which is ancillary to the problem.
Noted. With that, the chief and exam ends for the first defense, Your Excellencies.
Your Excellencies, may I begin with the cross-examination of DWI?
Yes.
Much obliged. Good evening, Dr. Michael.
Good evening.
Dr. Michael, since the bench had also pointed out and questioned on the scope of your expertise to be able to assist the court, and is it correct that you are a trained international law expert?
No, I'm not a trained international law expert. I am only a trained mechanical engineer, and since I've been associated with the US military for 20 years, I do have some insights into the legality of those weapons that are used.
Thank you, Dr. Michael. So it is correct that your main expertise is in the area of developing advanced weapons, but you're not a trained legal expert, right? Moving on to my next question. Just before the, and below you mentioned the, in the last line of your testimony that these weapons aren't even inherently indiscriminate. Can you please substantiate the same in your opinion as a technical expert?
Like I mentioned, that inherently discriminate implies that there's a distinction between the application to civilian and to the combatants. When you see the application of how a thermobaric weapon is used in terms of the heat and pressure that's involved, and it uses oxygen from the surroundings, it does not particularly distinguish between its application when it comes to where it's deployed.
Thank you, Dr. Michael. And I would request you to please keep your answers brief because you've stated most of it in your examination in chief. And since you mentioned that these weapons are not indiscriminate because they're able to distinguish between combatants and civilians in the target area. Is that correct?
Sorry, could you repeat the question?
You just said that these weapons are not indiscriminate because they're able to distinguish between combatants and civilians in the target.
No, I said they cannot, they are not indiscriminate because they cannot differentiate between civilians and combatants.
So you're saying they cannot differentiate. Dr. Michael, do you, as per your understanding, what do you mean by indiscriminate weapons? That,
like I already mentioned in my chief examination, that inherently indiscriminate means that they do not distinguish between civilians and combatants. And I did provide an example of the same in terms of the, there's a US Department of Defense manual, which mentions an example of this.
Dr. Michael, we've noted of what you, the previous example you mentioned. So just to conclude this line of questioning, you've stated that these weapons are not inherently indiscriminate and because they cannot distinguish between civilians and combatants, correct?
Yes.
Thank you, Dr. Michael. Dr. Michael, you drew an analogy to the usage of such weapons in Afghanistan. Is that correct?
Yes.
And you had mentioned that the reason for the same was the villagers participating in and leaking intel and so on and so forth.
Yes.
Dr. Michael, it is my understanding that you're an expert witness. So do you justify their applicability in the current scenario on the basis of your understanding of the factual circumstances of the case, or is it just an expert opinion about what happened in an unrelated situation?
It's just my opinion in drawing the comparison between what happened in Afghanistan and what happened in the case study of Titan.
Is it so? Since these were used in the area of lengthy and expansive mountains, and this posed a unique geographical challenge, correct?
Yes.
So the unique geographical challenge is one of the factors where you would justify their usage in Afghanistan, correct?
No, it is more about the leaking of the intel to the military, which is the reason for the drawing of comparison. If you see Afghanistan, despite its geographical location in terms of landlocked mountains and typically the Hindu Kush range that exists there, is not merely because of that, that's just an ancillary detail that was mentioned in the report and not something.
And ancillary detail being one of the factors, correct?
Yeah.
And would you justify their application in an habitated city?
So, sorry, I do not. It's not my opinion to provide in terms of justification of its use or not use. It's probably the court's decision to decide whether it's.
In your expert opinion, we're asking, since in your testimony, you offer your expert opinion on their usage, on their nature, and on their prior usage as well. So since you drew the analogy to an example to justify their usage, would you be willing to answer that? Is it justified in your expert opinion to use these in an habitated city?
So, like I said, it's a legal gray area, and because it can be argued both ways, either for the benefit or for the exploitation of the weapons. In the present case, the weapons have not been said in an unlawful manner, and there is nothing to say that the weapons might not be misused in a future date. And therefore, there needs to be probably just a clear stance to regulate them in the international law.
Dr. Serge, I don't think the question was about its legal regulation. The question was about factual impact. As an expert, would you tell us that it is appropriate or inappropriate to use bombs in this type of bombs, vacuum bombs in a crowded city? What is your opinion? It can be used or it cannot be used?
So it depends on, again, the military necessity that comes into picture, which is based on individual factual situations.
Your question, may I proceed with just a comment on the previous answer?
Sorry, could you repeat that?
This is a question. Just a procedural
Not
question.
sure that you should be commenting at this stage. You may comment in your closing if you want to.
Noted, Your Excellencies. I'll proceed with my next line of questioning. Dr. Michael, since you suggest the nature of these weapons, where you mentioned they create an adverse pressure reaction, which collapses, among other things, the human pulmonary system. That is correct?
Yes.
So is it correct to state that these effects are only and only limited to the specific target area? The pulmonary reactions and the adverse pressure reactions created in their detonation?
It again depends on the size and the nature of the bomb that's being deployed.
So they cannot be with certainty contained within the target area. With certainty, they cannot be contained.
Sorry, could you reframe that?
I will reframe that for you, since you've mentioned that it depends on the facts and it depends on the modification and the facts of the bomb. So it cannot be said that with certainty these can be contained.
No.
Thank you, Dr. Michael. Dr. Michael, you suggest these opinions about their non-indiscriminate nature and their usage being upheld by courts on the assumption that it is for vacuum bombs and thermobaric weapons, correct?
Yeah.
Dr. Michael, I'm not sure if you're aware of the factual circumstances. May I, to assist this court, offer one piece of opinion for the context? Mr. Paul Anderson himself had mentioned that this is an admitted fact that these were newly developed prototype of vacuum bombs. So just now with this, may I proceed with my next line of questioning on this? Dr. Michael, considering that these are different, these are newly developed prototype vacuum bombs, is it not correct that your opinion on vacuum bombs and on their nature might be different from the same on newly developed prototype vacuum bombs, which you have not studied or are aware of?
So if you see, the vacuum bombs fall under the large criteria of thermobaric weapons, and I have dealt with advanced weapons in that scenario.
Dr. Michael, but would it not be correct to suggest that since your opinion lies on vacuum bombs in general, and it is a newly developed prototype which has not been come under the ambit of scientific research and study till this point, so you cannot with certainty offer your opinion on the same?
Like I mentioned, there's
objection, Your Excellencies, if it's possible. It's a repetitive question. The witness just answered the same question.
Yes, I do think so.
My apologies, Your Excellency. I just wanted to pose a clearer answer to extract the same. No worries, no worries, Dr. Michael. We will move on to our next line of questioning. In your expert opinion, since you have said that their effects can go beyond the target area, though it depends on the circumstances, then is it certain that the effects could also be on the environment itself?
Since I mentioned that it does use the oxygen from the surroundings and creates a cloud within itself, there are repercussions in the environment.
Thank you, Dr. Michael. With this, Your Excellency, I believe the defense has to end their cross-examination. Much obliged.
Thank you.
Your Excellencies, before the victim's legal representative proceeds with cross-examination of defense witness number 1, may the counsel seek a clarification from the court, please?
Yes.
If I may direct Your Excellency's attention to page 21 of the compromise that contains the defense witness testimonial. Under general description, the last line states, now retired, the witness has been called by the defense legal counsel to provide perspective on the legality of thermobaric weapons under the extant framework of international laws and customs. On the basis of this, would Your Excellencies allow me to proceed with a line of legality questioning, because the defense counsel has brought this witness for that particular reason? Much obliged, Your Excellencies. May the counsel proceed with their cross-examination of defense witness number 1?
Yes.
Witness, do you recognize the testimonial on page 21? Was it given by you before the office of the prosecutor?
Yes, it was.
As a former professor of applied mechanics, what are your qualifications to talk about international law?
Like I mentioned, since I've been working with the US military for 20 years in developing the advanced weapons, I do have an understanding of the legality that's involved in that aspect.
Can you tell the court, for the benefit of the court, what customary international law, the elements of customary international law are?
So when you see customary international law, there are some elements such as it should be continued, it should be widely accepted by everyone, and it should also not be contrary to the practices that exist. These are some of them.
Would you state that not using thermobaric weapons is a widely accepted thing by most countries in the world currently?
Sorry, could you reframe that?
Would you state that not using thermobaric weapons is widely accepted by most countries in the world today?
There is no such consensus on this domain as of now.
Can you explain for the benefit of the court what jus cogens means?
Relevance, objection, Your Excellency.
Your Excellencies, the counsel is just trying to understand where the witness gets qualifications to speak on international law.
No, I'm so sorry. I mean, I was also, I was about to raise the same objection, but I'm glad. I think I should allow the defense counsel to raise its objection. You may clarify on your objection first, Madam Counsel, I think.
Yes, just asking out different principles of international law repeatedly does not have any relevance to the current practice scenario in question. So asking different what qualifies as customary international law, jus cogens or opinio juris is just repetitive and useless in the current scenario.
Much obliged, Your Excellency. The counsel will move on. Witness, have you ever been on active duty before?
What do you mean by active duty?
Have you ever been in the military or seen the effects of a war firsthand?
No, I have been helping them develop the advanced weapons with the US military.
I'm very sorry. I'm curious about this line of questioning. Is this witness a witness of fact? I mean, it's a witness of opinion. It's an expert witness, isn't it? Why does it need to be on the field? If it's a technical expert who's telling us how technology works? I mean, I don't understand what's the need to be on the field for such a.
Indeed, Your Excellencies, the reason the counsel was pursuing this line of questioning was to understand whether the witness is qualified to comment on the effects of bombs, because merely
Of course, why not? If somebody is researched, and of course, like I'm entitled to comment on neutrality and international humanitarian law without having seen combat. You can't say I can't comment because I'm an international lawyer. I mean, it's a very different kind of evidence which we have in front of us.
Much obliged, Your
I request you to stick to relevant issues, please.
Much obliged, Your Excellencies. Because you've stated that you have been developing advanced weapons for a really long time, can you tell the court what these advanced weapons look like?
Some of the advanced weapons include nuclear weapons. When we like the starting part of it deals with nuclear weapons, then there's the supersonic weapons that are there. There's the air-to-air rifles and so on.
Thank you. What is your understanding of a combatant?
Objection, Your Lord, relevance. How is that? How is the knowledge of a combatant relevant in the current scenario?
Your Excellencies, if I may.
Yes.
In the last paragraph of the witness's testimonial, the witness states that vacuum bombs were legitimate in Afghanistan, particularly because in light of their leaking intel to the militia. Therefore, the council is pursuing this line of questioning to understand whether merely leaking intel can qualify someone as a combatant.
How is that relevant to the, sorry, yes, I think you still have an objection?
I just want to continue. The word combatant hasn't been used at all, and it still doesn't prove the relevance of a question at current hand with the current factual scenario.
Absolutely, yes. Unless you can give us some reasoning to turn it around.
Much obliged, Your Excellency. The council will rephrase.
Well, wait a minute. This witness has been called as a military expert. So it's a very simple question. Who is the combatant and who is the civilian?
If I may, I'm going to disagree with my fellow judge on that, because the individual is not here as a military expert. He has an experience. He's a technical expert who knows how military technology works. I don't think he has any knowledge to tell us how to classify as a combatant, non-combatant, civilian, protected person. Even we international lawyers will spend days on discussing about these issues. These are technical legal questions which are being posed. So I think it's just getting way out of the scope of the testimony. Yes, you can ask questions about how far is the technical knowledge compatible with the legal knowledge, but you can't start questioning legal questions. I mean, it's for legal experts, not for a technical expert.
All right,
Yes.
so I would still allow the question because the witness has already testified that these bombs are not indiscriminate because they cannot differentiate between civilians and combatants. So she must have had something in her mind about how she distinguishes those two categories. So it arises from evidence given by him already.
If I may.
Yes.
So as per my understanding, combatant basically would mean someone who's directly or indirectly involved with the armed conflict.
Would you state that passing information is a direct or indirect involvement in a war?
It depends on circumstances.
I'm very sorry. I'm still confused. I want to know from the council, when you ask the question about combatant, non-combatant, you are asking it in law, or you are asking as a fact as to how will you distinguish a combatant from a non-combatant?
Your Excellency, if I may make 2 points of submission on that. The first is that the witness testified at the very beginning that they've been with the US military for 20 years and therefore have understanding of international law at the beginning of my cross-examination. And the second is that the witness also previously has used the word combatant in the previous cross-examination.
I have asked you a very specific question in order to understand what questioning you're doing. Were you asking a question in law as to how do you distinguish between a combatant and non-combatant, or in factual reality? And I think that's the divide between my fellow judge and myself. I'm saying you can't ask a technical legal question how to distinguish between a combatant and a non-combatant in international law. That's beyond the purview of this evidence. But you can certainly ask that in a given factual situation, since you have seen military action, how would you distinguish in reality a combatant from a non-combatant? So there's a difference between its distinction in law and what would happen in reality, according to me at least.
Indeed, Your Excellency. So the question was pertaining to factual reality, because the witness has testified that they don't think that these weapons are indiscriminate, which means they don't have effects on combatants. For that, the witness would need to understand what combatants were, which is why the council is pursuing this line of questioning. If Your Excellencies would prefer, the council is happy to move on.
Well, the witness has responded to your question already, so you can move on.
Much obliged, Your Excellencies. I think my time is up. No further question.
Thank you.
Witness, I have a clarification to be made. You mentioned that you are a mechanical engineer, Dr. Michael.
Yes, sir.
Okay, so you were denying that this is not an indiscriminate weapon. Thermobaric weapons are not indiscriminate weapon, mentioning that it is not an incendiary weapon, right? That's the statement you made.
Yes.
Okay, so as being an engineer, can you explain how these two weapons differ in actual performance? Because as far as I understand, both the weapons use the same technology of burning high volatile, discharges and creating high temperature. That's how it sucks in air, right? So how you distinguish these two and say that one is an incendiary weapon and thermobaric is not? Because as far as I understand, they use liquid fuels to burn to create air vacuums, right? That's how vacuum bombs work. So why you say that it is not an incendiary weapon?
So, I'd like to answer in terms of in thermobaric weapons, basically it's heat and pressure that's involved and uses oxygen from the surrounding temperature. And the effect to trigger the bomb is basically a chemical reaction which triggers the event. In terms of there are basically two chemical reactions that take place. When it comes to about the distinction, if we can refer to basically something like the explosive weapon effects report, which deals with basically the characterization of these explosive weapons.
Just to make it brief, because we don't have much time left. Please answer this question: whether thermobaric weapons, when they explode, will they create heat, excessive heat?
Yes.
Okay, if that is the case, how can you say that it is not an incendiary weapon?
Because
it's the same one.
Because they're technically not dependent or aimed at causing fire. That's not the first step. Because they're technically not aimed at or dependent on causing fire. They're more about the pressure reactions that are caused rather than the technical aspect about the fire.
But what you intend and what it really causes, there is a difference, right? So what we need to take into account is what it causes, not what you intend. Okay, thank you very much for your answer.
Thank you.
Thank you. Who's next?
Your Excellencies, with your leave, I would like to call Defense Witness 2 to the stand for Chief in Examination.
Yes.
Audible and visible?
Yes, Witness, you are. May I please begin with the Chief in Examination, Your Excellencies?
Yes.
For the benefit of the court, Witness, please state your name, nationality, and age.
I'm Paul Anderson. I am a citizen of Republic, and I was a former commander of the Delta Force 5 in the military of Republic.
Witness, what was your role during the period of the conflict in question?
Being the commander of the Delta Force 5 of the Republican Army, I was actually acting as an extended arm of the Republican president. In this regard, I was responsible for passing orders and on the on-ground action to be of the 150 people who were in my battalion.
Witness, could you please tell the court the response of the Republican government to the siege of Emerald?
Can you please repeat your question?
Sure. Could you please tell the court the response of the Republican government to the siege of Emerald?
Pursuant to the siege of Emerald and several other ambush which was suffered by the Republican Army, the presidency was furious with the lack of preparedness on the armed forces, and we were issued certain orders and directives by the Ministry of Defense. Our mandate was to redefine the loss that we have suffered.
Right. Could you please state the directives that were issued to you by the presidency?
Technically, our mandate was to redefine is absolutely based on the first blow that we received. And we were issued orders to use our battalion in the most effective way and to avenge the loss that we had suffered due to the siege of Emerald and other several strikes by Titan.
Thank you, Witness. Mr. Anderson, would you say that you had a choice to not follow the orders, or what would happen if you hadn't followed these orders?
I had no liberty to disobey the orders. There were certain soldiers who questioned these orders, and they were actually labeled as disobedient. And I was aware of how disobedience would be dealt with in our own country by Mr. Wallace. You would have at least been imprisoned up to 10 years, and you would also be prone to execution, especially during times of war. And in these circumstances, I was left with no choice but to obey and work according to the directives that were issued to me.
Thank you, witness. In your written communication, you stated that the civilians parading the street and town squares were hostiles. How did you come to this conclusion exactly?
I believe that after the siege of Emerald, it had taught me a very important lesson that any and everything that moves in Titan is a military asset and could be the cause of your death. Each and every movement of my troops was being reported by the residents in the form of tweets, Instagram reels, and other forms of social media. The intel which was provided by these residents, they allowed the Titan militia to completely
Is the defense witness glitching just for me or for the entire court?
For us as well.
Chamber Master, could you please stop the timer until the defense witness has come back to the stand? Thank you.
Yeah.
Yeah, sure.
Apologies, Excellencies. I think everyone is prone to technical issues despite COVID getting in. So I'm so sorry for that.
That's perfectly understandable.
The defense witness is back, I guess.
I'm extremely sorry. There was a power cut.
No
Extremely
worries.
sorry.
No worries, witness. Yeah, could you continue the answer that you were giving to the question, or do you want me to repeat it?
Can you please repeat your question?
Sure. In your written statement, you've stated that civilians were parading the streets and town squares were hostiles. How did you come to this conclusion?
So the siege of Emerald has actually taught me a very important lesson that anything that and everything that moves in Titan that was hostile and that could actually result in a militaristic action towards us. Mobile phone and everyone had internet access, and I believe that a 54-year-old grandmother could go on to cause more conflict than an actual person with a rifle. So I think that each and every part of our troops, day in and day out, was being reported, published, and projected for the upcoming attacks on our army.
Right. Could you also link that to the current factual scenario, and how did you come to this conclusion as in currently?
So there was absolutely no means that we could distinguish between civilians and combatants. Every civilian with a phone and access to internet was a threat. And because there were no means to pinpoint the exact source of information on our part, so the outreach was very significant, as these tweets were being reposted in a matter of seconds. And it was not possible for us to separate the role that was played by these civilians and the role that was played by the army in general. So for us, they were combatant from the very beginning and thus legitimate military targets.
Noted, witness. I think my last question would be, is that correct that the weapons you used were thermobaric weapons in the present case?
Yes.
Okay, so my last question to you would be, did you have any knowledge on the legality or the illegality of these weapons?
See, I'm also a specialist operative in advanced military weapons. I absolutely did my due diligence, and I can say with certainty that these weapons are not prohibited under international law, especially in the context of, say, hostile civilians who are parading in the squares and streets and leaking intel to the other militia.
Noted. Thank you so much, witness. Your Excellencies, with that, the chief in examination ends for this witness.
Thank you.
Your Excellencies, may the prosecution begin with the cross-examination.
Yes, please.
Much obliged. Good evening, Mr. Anderson.
Good evening.
I was just checking if I'm audible or not. Thank you. Mr. Anderson, you had mentioned that you are a specialist operative in advanced military weapons, including thermobaric weapons, correct?
Yes, during my academy days, I did research on it. Yes.
Thank you, Mr. Anderson. And being a specialist operative, you would know how to operate the weapons, choose the target, and the intended objective to achieve the same.
During my academy days, I was actually researching more on the development of prototypes of these vacuum bombs, the newly developed prototypes.
So do you mean to say that you were, during your course of study and research, totally unaware about what effects they would have?
No, I was absolutely sure of the effects.
You were sure of the effects they would cause. Thank you, Mr. Anderson. Continuing on this, you mentioned that they were newly developed prototypes, correct?
Yes.
So how did you ascertain the effects they would have, considering these are anyways these were newly developed prototypes, and what necessary or reasonable precautions were taken from your side to ascertain their effects?
So I developed these newly developed prototypes with the collaboration of the governmental resources, as well as the government, as well as the team that the government sent. And the entire development of these bombs were not in my hands. So I'm technically not an expert of the entire development of these bombs.
So just a small question again. Is it correct that there was no testing taken place on their effects of these weapons, of the newly developed prototypes?
There was testing that was in place, yes.
Your Excellencies, may I, continuing on this line of questioning, may I draw the attention to the line where he says that no international instruments govern the use of deployment of such weapons? Mr. Anderson, could you tell us your reason to our rationale for the same?
We were certain that no international instruments govern the use of deployment of thermobaric weapons. Particularly, it is important to note the context as well, where I also would add that particularly against hostiles who are parading as civilians, and there is no way that there can be a distinction that can be drawn out between civilians and combatants, as I studied in my IHL course as well.
Thank you, Mr. Anderson, for your answer. Mr. Anderson, you had mentioned in your testimony that you were acting as an extended arm of the David Wallace presidency. Is it correct that you were you aim to achieve the objectives as entailed?
Every military directive that came from David Wallace was to be achieved by the military, yes.
Thank you, Mr. Anderson. Mr. Anderson, continuing on this line as well, were you given specific directions on the same, how to conduct the attack?
The entire military was given military directives on how to conduct the attack, yes.
Mr. Anderson, I believe that is not what the question I was asked. Were you given directions on how to conduct the attack, or were you just given a direction to achieve the objective of the said attack?
The military directive stated in order to avenge the sieges as well as the pursuant attacks of the opposing army in a way that was deemed necessary.
So, and you were assigned this task, and maybe one of the reasons being that you have an illustrious career, you're the youngest commander and a specialist operative in advanced military weapons, correct?
Correct.
Objection, Your Excellency, the repetitive question. The witness already
Excellencies, I would request that I would request that may I please continue with my next line of questioning, that this leads to this leads to establish the link between the same, and it is required.
I think this preface was necessary. It wasn't unnecessary according to me. So I think the question should continue. The preface was correct. The questioning should continue the way it was going on without any objection.
Much obliged. Mr. Anderson, as you just suggested that you mentioned, just to, because the flow of questioning was interrupted, I would just like to give back the context in order to get back in it. You mentioned that you were given directives and objective to achieve, and then one of the reasons for the same, that you were in youngest commander in illustrious career and in specialist operative in advanced military weapons, correct? Till here?
Yes, you're correct.
Thank you, Mr. Anderson. Mr. Anderson, since you were just entrusted with the task, you were given the freedom, as you had stated, to plan, prepare, and execute the response, correct?
No, I don't think the military directive gave that much freedom to the military.
Since you just stated that the objective was to just, and as per your testimony, draw titanium blood on the street and a spectacle to be made immediately and cause maximum loss of assets. That is, I understand, as you've stated, the objectives. But in order to achieve the objectives, the plan and the formulation and execution, it was in your hand, right? You were entrusted for the very reasons you've just mentioned. Your expertise.
But there's no war in the world without bloodshed, right? That statement was given after the 120 men out of 150 men were
I had not
from my
asked you
battalion.
I apologize for interrupting in between, but I had not asked you whether there can be a war without bloodshed or not. I would request you to please keep your answers precise to the point, so as we don't waste the time of the court. And the question was asked whether you were given the freedom to exercise the same, to, as you had stated, to plan, prepare, and execute a response.
It was a direct military order. However, the development of the vacuum bombs and the prototype, I was in the team developing the newly developed prototype of the vacuum bombs. Yes, but there was not much freedom that was presented to the military.
And you had stated that there was not much time as well, right?
Yes.
So as you had stated earlier as well, that the newly developed prototype, within the less time, you had prepared, planned, executed, and developed the newly developed prototype and conducted their tests as well.
Yes, we were aware of the effects of that bomb. Yes.
Thank you, Mr. Anderson. Mr. Anderson, as you suggested that you use your battalion in the most effective way, what do you understand by the same?
That our battalion was achieving the objectives it was used to achieving.
Thank you, Mr. Anderson, for that response. You had stated repeatedly in your testimony that in the written testimony that any and everything that moves was a target. And you had stated in your examination in chief that every civilian there was a target. Is that correct?
Every civilian was a military target because they were moving and they were leaking intel to the other aggressors. Yes.
Mr. Anderson, having said that, so considering your opinion on the same that you did not consider, and this is just to further the line of questioning and not an admission of the fact that you considered every person had lost their civilian status for leaking intel. Every single person in the city.
Every civilian in the city, because everybody was moving and leaking intel. And while there is an IHL distinction, we tried to make it, but it was actually impossible in order to differentiate between a civilian and a combatant at that point of time.
Mr. Henderson, having said that, considering that you considered as every civilian as in combatant, how were you able to make the assessment of the same, that every person was leaking an intel?
Objection, Your Excellency, is a repetitive question. The witness just established how he thinks everyone was a combatant and not a civilian.
Your Excellency, may I respond?
Yes, I think so.
Yes.
I should respond.
Your Excellency, I understand that the line of questioning may be repetitive, but the counsel for the prosecution is trying to establish a certain specific and non-ambiguous answer out of the same so as to curtail and increase the scope.
I think you should continue. You were going right.
Thank you, Your Excellencies. And I would request the defense counsel to not interrupt the flow of questioning if possible.
Yes, that's what I was also going to propose, that it would be helpful not to raise too many technicalities. It just disrupts the flow. If necessary, you can also give a prefatory question and again sort of frame your question again. I think we were on to something interesting.
Much obliged, Your Excellencies. Just to restate the line of questioning we were going on. Since you had stated, and just to recapitulate the last three questions, you had stated that every person and any and everything that moving was a target, and it was your understanding that every civilian was a combatant because, as per your understanding, all of them were leaking tactical information to the military, correct?
In times of war, it is more important to understand that the collective weight of hatred.
I'm so sorry to interrupt you, but I believe this was just a reconfirmation of the same, what you've already stated, to continue on a line of questioning which was interrupted.
I'm sorry, but I don't think that's a yes or a no question that you asked. A bit of explanation was needed on that part.
I apologize, Mr. Anderson. So would you want me to ask all the questions again, which you have answered in the affirmative?
No, I would like to provide a bit of context on that statement.
I think the witness is only referring to this question. He wants to elaborate on this question. I think it will be unfair to curtail him. I think he should be allowed to respond fully.
Indeed, Your Excellency.
On this question as well.
Indeed, Your Excellency. Though, as I stated, the question was was just in continuation of the previous line of questions, which was affirmed and interrupted, and just as a prefatory question to continue the line.
But the witness wants to give an explanation to that. I think it would be very unfair to stop the witness from doing that.
Mr.
Anderson,
Mr. Anderson.
So technically on the question that was every civilian was considered or not, I don't think it's, I think it's futile as of now, because the collective weight of hatred and the collective might of hatred of social media reporting with the one and only linked community objective of destroying our forces was enough justification to do what our entire forces did. And I think that at that point of time, a decision on every civilian can't be made. But I think that the collective weight and the collective might of what the civilians were hoping to achieve and they were able to achieve was enough justification for what we did.
Mr. Anderson, so in this collective or cohort of the hatred towards a republic of the civilians of Titan you present, so do you infer from that same that all of them were using social media, or is it that some of them were and the rest were just included and targeted because of being a part of the cohort?
Again, I said collective weight and collective might of hatred was enough justification for for doing what we did.
Thank you, Mr. Anderson. So Your Excellency is a point to be noted. And Mr. Anderson, I would just like to conclude by asking that you had mentioned in your testimony that you would be subject to, and I quote, 10 years of imprisonment and could have been executed as well. Is that correct?
Yes, that was a possibility. Yes, if I disobeyed the order.
Mr. Anderson, can you please substantiate the same, that since nothing of the sort is presented in the compromise or the annexures or your statement itself?
My 14 years of experience in the military, I've seen enough comrades and enough commanders who have disobeyed the direct military directives. They have been executed and they have been in prison for life.
Thank you, Mr. Anderson. With this, Your Excellencies, the Counsel for the Prosecution would like to conclude their cross-examination.
Mr. Anderson, I have one question. I might be repeating what the Counsel for Prosecution was asking, but I want to make it a bit more finer and a bit more sharper, if you could help us on that. At any stage of your planning, did you decide or use any measures to distinguish between civilians and combatants, or individuals who you thought are the ones who are aiding the military and those who are not aiding the military?
Your Excellency, at that point, there was no difference in the role that was played by the army and the role that was played by the civilians in order to leak intel and militia. And they knew our top-notch strategies, they knew our execution, they knew our planning from leaking intel through social media, through posting Instagram reels. And I think that that was enough reason for us to do what we did.
Just
You
if
have
I may,
do you have a follow-up question, Judge
Yes, I'm
Lightfoot?
terribly sorry for that. Did you at any stage, because I think nowadays technology is very advanced and you can locate where who is sending what from, did you make any effort to at least have some sort of mechanism to find out whether the places where dropping bombs are the places where there's a more concentration of people, unlike say any other spot? So when you chose the spot, when you say it's a military necessity, why did you just drop it at a certain place? I'm sure there must have been something you must have thought while dropping or ordering it to be dropped at a certain locality. What was that reason?
We absolutely looked into certain concentration where combatants were heavily located, and the usage of our dropping bombs were highly precise, because in our newly developed prototype we made it highly precise targets. And I think that the entire distinction, that where there were a majority of combatants, that was the location where we dropped the bombs.
And by combatants, you mean the actual military person and not these civilians who you treat as combatants?
Actual military person.
Thank you.
So I have a question as well, Mr. Anderson, and it relates to the fact that how do you establish a link between information being posted on social media by civilians? And that's all they did. They're not the parties who took the next step of attacking your forces, right? That was used by the defense forces of Titan. So how can you hold these civilians who put out information on social media, so much so that another witness told us this is a global trend of civilians using social media, and you told us that you determined that all civilians are legitimate military targets, but they stopped at posting the information. It's another party that acted on it. Do you have any comments on that?
Your Excellency, all our planning strategies and all our locations through which we were moving, they knew exact locations and it was pinpointed. And there were several strikes which actually nullified our absolutely thought about strategies for days. And I think that leaking. So we got aware of that fact because our precise locations and our precise strategies were being leaked by the civilians. And I think that in IHL, there is a big distinction between civilians and combatants. But in this, there was no distinction and it was amalgamated. And I think that leaking of intel played a very harsh blow to our own battalion and our own Republican army. So I think that that was the main reason why we did what we did.
All right, thank you. Any other questions for this witness?
I have one question with the permission of the chair. Mr. Anderson, you said that the social media put threat to you and your defense arrangements, etc. In the social media, a person can post information about an incident and about a particular event, and he may share his live location, but he cannot share the live location of the bombing or the live location of the military movement or military operation. And how can sharing of an information be a threat to your operations or your safety? Can you justify something?
Your Excellency, every troop deployment, every movement through the city, and every amalgamation of forces was being leaked and was posted on social media, which was again being sent by us from the government itself, who were looking into this matter. So I think that the entire siege of Emerald, which took place, killing 120 out of the 150 people, was entirely based on the tweets that actually located and which were posted on the internet, which actually located our entire battalion. So I think that that justifies it.
Okay, thank you. Then my one last question. If that is a inference you draw, then would you justify killing of all civilians who put information or who share information on social media through this bombing?
Your Excellency, we followed the safe harbors of military necessity exceptions during this time as well. We made sure that there were majority of combatants, and those were heavily concentrated places of combatants where we dropped the bombs. We also made sure that the newly developed prototype of vacuum bombs were highly precise targets, which do not affect more places as it should, which it has the objective of doing.
Thank you, Mr. Anderson.
Mr. Anderson, a quick question. This is regarding your statement that you are you were a part of developing this new weapon, and you also mentioned that you have trainings. You already had trainings on international humanitarian law. So you also mentioned that there is no prohibition in developing these type of weapons. So I was wondering whether how you justify development of these kind of weapons under Article 36 of the Additional Protocol 1, which talks about developing new weapons according to the international humanitarian law. Have you gone through those aspects of international humanitarian law while developing this weapon?
Your Excellency, at that point of time, we were just following a military directive. I'm not a legal expert. I'm not aware of what the article says, but we didn't want, as commanders, we didn't want to be disobedient to Mr. David Wallace, as well as our entire government at that point of time.
But you as a team have never gone through the veracity of this new weapon under the international humanitarian law, right? That's what you want to see.
Your Excellency, I'm not aware of that legal point.
Okay, thank you.
Your Excellencies, with your permission, may the victim's legal representative proceed with the cross-examination of defense witness 2?
Yes, please do.
Much obliged, Your Excellencies. Can you confirm that the statement on page 23 of the compromise is yours?
1 second. Yes, it is mine.
Thank you. In your 13 years as a commander, you've testified that you are familiar with the principles of international humanitarian law. Correct?
Specifically, the civilian distinction and combatant distinction. Yes.
In that case, what in your opinion distinguishes a civilian from a combatant?
When civilians are heavily affected and they do not go on to support the combatants through leaking intel militia or through any other aid or assist.
In this present case, did you see or hear of any civilian picking up a gun or any other weapon or attacking your troops directly in any way?
They were leaking intel through social media, which I believe was more harmful to us than picking up a gun. So the intel was enough.
So is your testimony that there was no direct participation in that they never picked up an arm against your troops?
Leaking intel is a direct participation.
But witness, can you answer the question? Did they or did they not pick up weapons against your troops?
Depends on what you mean by weapons. I believe that social media nowadays is a weapon itself.
I'll move on. Can you explain what your role as a commander entails?
I'm the commander of 150 men of the Delta 5.
Is that to say that you have a lot of decision-making power in the military?
Of all the 150 men, yes.
Does that mean that with respect to those 150 men or any other decision you make in the military, you needed to run every action of yours by Mr. David Wallace or the Ministry of Defense?
I have to work according to the military directives and objectives as released by the Republican government, yes.
So in a time of crisis, if you were to make a decision, would the decision be made by you or would it have to be run by the Ministry of Defense?
Macro decisions have to be run by Mr. David Wallace.
In this particular case, what was the macro decision?
Issuing a military directive in order to get back on the Titanian government after the siege of Amaral and other strikes which affected us.
So the means and methods of getting back on the Titanian government was never given to you in the directive, is that correct?
No, it was not.
That was a decision that you took by yourself, is that correct, Mr. Anderson?
But the government actually utilized a lot of resources as well as it deployed a lot of scientific men who developed these prototypes of vacuum bombs.
That's fair, but the deployment of thermobaric bombs was a decision that you took by yourself, Mr. Anderson?
I believe that use of vacuum bombs is imperative in these kind of situations.
Madam Counsel, I'm very sorry to
Will
interrupt.
you answer the question, witness? Answer the question.
Much obliged, Your Excellency.
I have to say, I was feeling that the witness is bulwarking your questions, but I think we have enough evidence on that point about the involvement of at least we have heard at least about his involvement in giving orders, dropping the bombs. So I don't think it really helps to ask the same question again and again. We'll keep bulwarking and we won't make any progress. So I suggest either you have a different formulation or have a different question altogether.
Yes, Your Excellencies. If Your Excellencies will permit the witness to answer, the counsel could take forward the line of questioning. If not, the counsel will move to a different line of questioning.
We can't direct an accused to give an answer which you like. It's the choice of the accused. Whatever answer he gives, he or she gives, we have to take it on the face.
Let me step in here. Counsel is busy asking you on what exactly was in the directive that you received. Was there a specific directive that you use these thermobaric bombs, or was that your decision?
Your Excellency, there was no mention whatsoever for the usage of thermobaric weapons, but Mr. David Wallace made it very clear the objective that was to be received. Now, as a commander and as an expert on developing the prototypes of vacuum bombs, I believe that vacuum bombs were necessary and pertinent in these situations, and they were the most effective bomb in this situation.
Yeah, so that's your explanation. Yeah, we get it. But the decision was yours alone. I'm just following up on counsel's question.
Choosing the weapon was my decision, but it was again run by the government because they developed a team and they sent over the resources. So it was first of all passed through Mr. David Wallace.
Sorry, I have a clarification now. I was under the impression, after listening to the entire evidence, that you were the one who had ordered the use of bombs. But I get the impression now with your clarification that it wasn't just you, but you had to get permission from your superiors as well. Is that correct?
Yes.
Okay. Thank you.
Excellent.
Your Excellencies, may the counsel proceed?
Yes.
As you stated in your previous cross-examination, this directive was given to the entire military. Is that
yes,
correct?
It was.
Are there other commanders in the military on the same rank as you are?
Yes, there are.
Would it be true to state that they also received these orders?
They also did receive these military directives, yes.
Why were you the only commander that deployed the thermobaric weapons in that case then?
Because I was an expert in developing the prototypes of these weapons.
Your Excellencies, this is all to prove that the witness, the accused in this case, specifically chose the thermobaric weapons himself, despite him stating differently in multiple occasions. Would it be true to then state that you were not under a threat to life since other commanders who received this order abstained from taking a decision on this order?
I was an absolute imminent threat of life while taking this decision.
Why is that not true of the other commanders in the military then?
A lot of commanders disobeyed this directive and they were held to be disobedient by Mr. David Wallace. And they would be facing wrath when they would go back to the government.
What kind of disobedience?
Did they face any consequences?
That was going to be my next question.
That's what you were asking? Yes, thank you.
What kind of what was the disobedience that was meted out to them? What are the consequences that meted out to them due to their disobedience?
Not these commanders, but according to my past experience in the army, especially in times of war, if you go on to disobey a military directive, there are high chances that you will be imprisoned for life and might be executed if you're at a high level in the military.
Thank you. So it would be true to state that in the present case, other military commanders have received this directive and have faced no consequences for abstaining from taking orders on this directive, correct? It's a yes or no question. It's a yes.
They will be facing the wrath. They will be facing the wrath.
But they have not yet. Thank you. Why did you have access to the troops that were put out by Titan? I mean, the tweets that were put out by Titanian civilians?
Can you please repeat the question?
Did you have access to the tweets that were put out by Titanian civilians?
The government did, and they passed on that information to us. Yes.
But the tweets were made on Twitter, which is an open access platform, which would mean that as a Republican or any citizen, really, you would have access to this information. Is that correct?
During times of war, we didn't use mobile phones.
Your Excellencies, if the council may request for an extension of 2 minutes, seeing as the beginning of this investigation, the cross-examination, the witness was not answering questions, if Your Excellencies permit.
Well, I think the witness is perfectly within its discretion not to answer, but you can have more time. But I have to say, I'm quite disappointed with your line of questioning because you've been asking the questions which are already established. And in a sense, you've probably weakened the prosecution case, which is perfectly good for us because we have to be fair in the process. But it's your choice. You might be damaging your victim's case by asking unnecessary and wrong questions. But it's your choice. I mean, you can certainly go ahead and take a call on this. Of course, subject to the chair's discretion of whether we can spend another 2 minutes on this.
No further questions, Your Excellency.
Well, thank you. Thank you, Mr. Anderson.
Thank you.
Do we use the time now for concluding arguments?
Your Excellency, with your due permission, the prosecution would like to begin with the closing statement.
Yes.
Much obliged, Your Excellencies. Your Excellencies, we believe that the bench wanted to clarify our stance on the recharacterization. Your Excellencies, if I may answer on that lines.
Yes.
Much obliged, Your Excellencies. Your Excellencies, initially, we only pressed the charges under Article 8 to B20 as we were not sure as if the charges under Article 8 to B1 were not being fulfilled. And in the case of uncertainty, we refrained from pressing the new charge of 8 to B1 as in the light of principle of Article 22 of the Rome Statute. However, Your Excellencies, we also fairly submit before this court that having read the written submissions of the victim legal representative on the addition of this charge and having re-evaluated the legal burden to be discharged under Article 8 to B1, we are of the firm position that it would be appropriate to add the charge of Article 8 to B1 as there exists an abundant material to prove the charge beyond reasonable doubt.
Sorry, is this any additional material you have got in addition to the one which you used while placing charge?
No, Your Excellencies, but we were uncertain at that time, and that was the reason that we did not charge the accused.
What I've been trying to understand is what is that intellectual gap which pushed you from uncertainty to certainty, which I'm still unable to find. It would be helpful if you could elaborate on it.
Your Excellency, at that given time, there was also a point of legal determination of the civilians, and we're not sure that what was the status of the civilians at that point. We're not sure about their status as they were combatants or civilians, and that's why the charge was not placed on the accused.
Okay, you may proceed. Thank you.
Proceed. And Sure, Your Excellencies. Having said that, we would like to move to our first submission. Your Excellencies, we submit that the accused is liable for the war crime under Article 8 to B1 as the following elements of Article 8 to B1 are fulfilled. Firstly, the perpetrator directed an attack. In this instance, Your Excellencies, the accused did direct an attack, and the same has been fulfilled and confirmed by the accused himself in his statement that he himself planned, prepared, and executed the attack. Secondly, Your Excellencies, the object of the attack was a civilian population not taking direct part in the hostilities. In the present case, Your Excellencies, the action of the civilian population.
I'm very sorry to interrupt. In the evidence that we heard, the accused also told us that he ran it through the senior officials of his country. Why did the prosecution decide not to prosecute the senior officials of his country, including the president, if he was involved in approving of that decision?
Your Excellencies, I missed some words due to unstable internet connection. could you please repeat?
I will repeat myself. While we heard the accused told us that the decision to drop was not exclusively his. It was also run through with the senior officials, including the president. Why didn't the prosecution also decide to prosecute his superiors, that including the president?
Your Excellencies, apart from this case, as it is given in the compromise, three other people are also charged for different charges under the Rome Statute, and this case only pertains to the charge on the commander Paul Anderson.
Are they the seniors, including the president? The other three individuals? Who are the other three individuals?
Your Excellencies, we are not clear from the compromise that the president, David Wallace's charge, is being charged for this crime, but other commanders and soldiers were being charged for the war crime of murder. Your Excellencies, I would like to request that I am facing an unstable internet connection. Can I use my co-counsel's laptop? It would just take 10 seconds for me.
Much obliged, Your Excellencies.
Yeah. Well, that's what's happening to me. I switched to my iPad a long time ago.
Your Excellencies, the council would be speaking from my mic henceforth.
Your Excellencies, could you hear me?
Yes.
Sure. Your Excellencies, second, if I may proceed, Your Excellency, in the present case, the action of the civilian population failed to meet the cumulative criterion required by the ICRC interpretative guideline. Your Excellencies, the three elements of the direct participation in hostilities, as has been laid down in the case of Tolimir, are not met here. Firstly, the act failed to meet the required threshold. Secondly, there was no direct causal link between the act of the civilians and the harm caused. And thirdly, there was no belligerent nexus between the acts and the harm caused. Allow me, Your Excellencies, to substantiate as to how all the three elements have been satisfied in the present case. Your Excellencies, the action of the civilians of tweeting and posting on social media at best constitutes as an indirect participation, as it does not meet the criteria of threshold of harm. As stated by the victim witness too, that the use of social media was used to safeguard the people that they love and not to help the government of Titan. Your Excellencies, the absence of a belligerent nexus and the intent of the victims fails to establish the cumulative criteria of direct participation.
I'm sorry, on the first criteria, because we have some evidence on our record, and I'm curious, how does it fit into your argument? For example, at page 33, it said, "Hey, movement of guns through Street 7, stay alert." Or 34, guns now spotted at the Red Square. Are these not sufficiently clear material? I mean, how would you respond to this material? Where would you fit this in your first argument, first threshold?
Your Excellencies, if you would read 3.4 and 3.5, they have said, please stay safe. Your Excellency, these tweets should be read in the whole context. These civilians were trying to help their fellow citizens to stay alert and ensure their safety during the times of armed conflict. So there was no intended act to help the Titanian government, and they were just, as in the contemporary world, it is very normal to use the social media to communicate and help fellow citizens.
So you're arguing that it's perfectly legitimate to give all information about wherever you spot arms and ammunition, and the hope that information would not be used by the combatants.
Your Excellency, these tweets were tweeted on their personal handles and not tweeted on any government handle. So it was just
so according to you, is it necessary that every time the tweet has to come from government handle for somebody to be a combatant? I mean, that would be a very high threshold, isn't it? And nobody would ever able to meet that threshold. I mean, law would become redundant then.
Your Excellencies, but in this case, there was no direction or order from the Titanian government that the citizens had to help them or have to help them by giving the coordinates. They were just helping their own citizens.
But would such an order be necessary? Is that a requirement under any of the convention, that there has to be an order from the government, or the action has to be attributable to the government to be attributed, and for deciding the combatant non-combatant status? Anything in law?
Your Excellencies, it is not such. But Your Excellencies, I would also like to state that the citizens did not have any mens rea to help the government. They were just helping their own citizens. There did not existed any mens rea in this case.
No, we are not on mens rea. We are not prosecuting them. We're not prosecuting the citizens. We are just trying to look in the context. Is this sufficient information to characterize them from being non-combatants to combatants because they are aiding in the military exercise?
Indeed, Your Excellencies, Your Excellencies, I may prove this in the next part of the next element of the direct participation in hostilities, which is belligerent nexus. If I may, Your Excellencies.
But before you come there, is it always necessary to have a direct belligerent, have arms and participate in order to be treated as a combatant?
Excellencies, because these are the three elements of the direct participation in the hostilities, and it has been laid out in the case of Ptolemy.
Okay, please, I'll move to that. Thank you.
Indeed, Your Excellency. Your Excellency, the absence of a belligerent nexus and the intent of the victims fails to establish the cumulative criteria. As stated by the victim witness 2, the civilians had no intention to be the eyes and the ears of the government, and people were tweeting in the war with the intention to stay safe and connected. Your Excellencies, in such a scenario, the protection of the civilians is not lost, and any attack targeting them is unlawful. Your Excellencies, the third element of Article 8(2)(b)(1) is the accused intended the civilian population to be the object of the attack. Your Excellencies, as laid out in the Codex.
I'm so sorry, stop it. Before we get there, can I just put a counterfactual to you? If we hold that the tweets were put out for multiple reasons, for example, the person tweeting is tweeting to protect themselves, but also hoping that this will be used to fight back against the enemy. Would that in your mind suffice to meet the threshold of direct participation in hostilities or not?
Yes, Your Excellency.
Thank you. Please move on.
Moving on, as laid out in the Cordic and Circus trial, Your Excellency, the mental element of the unlawful attack on civilians is based on two conditions. Firstly, the civilian status of the people who were armed should be known to the accused. In the present situation, Your Excellencies, the examination of the accused makes it abundantly clear that the citizens were certainly the targets, and it was a conscious decision to attack them indiscriminately, as he himself stated that every person had lost their civilian status, which substantiates that the accused was aware of the status of the civilians. Secondly, Your Excellencies, the attack should be willfully directed at the civilian population. The accused admitted in his statement that the Republican armed forces changed their mindset. Earlier, they were conditioned to observe civilians as non-combatants and non-targets. But for the purpose of the war in the Titan, they had to unlearn those training modules to plan their execution. DW2 also stated in the cross-examination that he intended to attack all the civilians, and thus he had definite intentions to make the civilian population not taking direct part in hostilities the object of the attack. And thus the prosecution submits that the accused is liable for the charge of Article 8(2)(b)(1. This permit, I may move on to the second submission, which states about Article 8 to B20. Your Excellencies, the repeated use of vacuum bombs by the accused violates Article 8 to B20 of the Rome Statute. Within this submission, we submit that A, the weapon that is vacuum bomb caused superfluous injury or unnecessary suffering. And 2, that the fuel air weapons qualify as being indiscriminate. Your Excellencies,
if I may, before you get there, it also has to be a repeated use, isn't it? How do you establish the repeated use?
In case the bomb was used 7 times, and that was a repeated use. It was not used once. It was used 7 times, and I will point out in the complaint.
Over a period of time or at one time?
Over a period of time, Your Excellencies, on page 10, 10 paragraph C, you can refer that the use of such weapons by the accused, as per estimate submitted within a period of 3 days, from October 22 to 25, the accused used these weapons on 7 occasions.
3 days, is that an enough test? Is there any test in jurisprudence on what's the meaning of repeated use?
Your Excellencies, the council is not aware of the same.
Okay, no problem. You can move on. But of course, subject to the discretion of the president, I think you're way beyond your time. So you may also want to be brief now and just hit the points which matter and just move ahead. Thank you.
Indeed, Your Excellencies, the council would like to submit that this vacuum bomb cause unnecessary superfluous injury or unnecessary suffering. As I would just point out to you that in the Annexure 4, the last paragraph says that the walls did not shudder this time. Instead, the very same reliable bunker, our second home, melted before our eyes and dissolved our own bones and the skin within it. Your Excellencies, this bomb caused superfluous injury and unnecessary suffering. Moving on, Your Excellencies, this brings me to the last prong of this argument, that these weapons are highly restrictive and lack the necessary precision to be used in a discriminate manner, and thus are indiscriminate in nature. Your Excellencies, with this, the council would like to conclude that the accused should be liable for the war crime of murder under Article 8 to B1 and 8 to B20 of the Rome Statute. It was an honor to plead before this bench, Your Excellencies.
Thank you. Who's next?
The victim's legal representative seeks permission to address to the chamber its closing statement.
Yes, go ahead.
Much obliged, Your Excellencies. Mr. President and Your Excellencies, the case of the prosecutor versus Paul Anderson before this honorable court concerning the war crimes committed by the accused under Article 8 to B1 and Article 8 to B20 will remain lingering in history as one of the most horrific acts committed on people that did nothing to deserve it. The indictment of Mr. Paul Anderson not only serves as a conviction and enforcement of international law, but as a hallmark of justice in the present trial. During the course of this trial, we plead the court to acknowledge the brutality of harm carried out on the victims, and we hope that we can chart a better course for their future. The victim's legal representative would make submissions under 3 limbs to prove this. Firstly, that the accused is liable under Article 8 to B1 of the Rome Statute. Secondly, that the accused is liable under Article 8 to B20 of the Rome Statute. And lastly, that the victims will plead reparations as under Article 75 of the Rome Statute. Moving on to my first limb, with respect to the commissions of war crimes under Article 8 to B1, the accused had the intention and directed an attack on the civilian population, proved through the witness testimony of defense witness number 2, the accused Paul Anderson himself. The defense counsel in their opening statement stated that a majority of civilians had been involved in social media, but the accused stated in his cross-examination that all civilians acted as combatants, but was unable to provide evidence for the same. This shows that the accused attacked civilians not taking direct part in hostilities, which is a gross violation of the principles of international humanitarian law, as there is a high threshold to protect civilians under Article 51C of the Additional Protocol 1 to the 4th Geneva Convention, and as well as the Rome Statute. And under no circumstance can the accused state that he could not differentiate between civilians and combatants. As held by the ICTY in the Blaskich case, the intent required to establish the offense of willful killing exists once it has been demonstrated that the accused intended to cause death. Moving on to my second limb, with respect to the commission of war crimes under Article 8 to be 20 of the Rome Statute, the weapons that were used in the present case are inherently indiscriminate and have caused superfluous injury and unnecessary suffering to the civilians. The council would like to make a submission here with respect to Your Excellency's questioning on the capacity for victim as an expert witness. According to the manual for legal representatives provided by the ICC, victims enjoy a dual status as per their testimony and can still be accounted for despite being interested parties. The same was held in the prosecutor versus Lubanga case. Therefore, the witness clarifying as to the thermobaric bombs being unable to differentiate between civilians and combatants during his cross-examination, which was done by the prosecution, admits that he knows that they were inherently indiscriminate in nature. As stated by victim witness number 1, who is a weapons expert.
I may on that, sorry. Is the decision, again, I'm asking I think we have had this brief discussion before, but does the Mubanga case say that you can be a victim? I mean, I can understand the situation as a victim. You are interested because you're the one who is suffering and you have to be heard. So, but as a factual witness, but can you also put on a hat of a scientific and technical expert, which is a completely different exercise? Does the decision say so, or does the manual say?
Your Excellency, the decision does not say that. There's no precedent for a victim being an expert witness, but this present case can lay it down. The manual says that any interested party can be an expert witness, which is why we stated that a victim can be an expert witness.
But let us understand the consequences of this, because the moment somebody is an expert, it's beyond our scrutiny. I mean, we can only, unless it's absolutely unreasonable. Otherwise, our hands are tied because we are not an expert on the field on which the witness is an expert. So we have to go by the word of the witness. The best we could do is we do a hot tubbing, get the two witnesses sit together and try to figure out who's the most sensible one. So that's a very different exercise. And the moment when it's a victim and the victim has an interest in as an expert, then we doubt if we can really blindly rely on such evidence of in the capacity or by a victim in the capacity of an expert. I mean, for example, the International Court of Justice has been very critical of experts being presented as counsel, because then you don't have the necessary fairness that an expert needs to have. So on prima facie, I don't feel very convinced unless you can convince me otherwise.
Your Excellency, if I may make one last submission, unless you would prefer that I move on. So in the Lubanga case, what was held is that a witness can be introduced in any capacity. It was held that they can be introduced as a victim can be introduced in any capacity as a eyewitness or as an expert witness. That does not diminish his standing in the present case, because in this case, the witness was a victim. We've said that he can.
Which paragraph is that of the judgment?
Your Excellency, let me just pull that out.
Because I'm curious, if the court has said that it can be expert, then of course we have to follow that through. I mean, maybe you can provide us the reference later and you can proceed with your...
Much obliged, Your Excellency. The council will just put it in chat when...
But I'm sorry to interrupt. In continuation of what my learned judge has referred about the dual role of the victim as an expert, as a witness. If you peruse the provisions of Article 68.2 or 68.3 of the Rome Convention, there is no distinction between an expert and a victim witness. It simply says victim can be a witness. So even if, presuming that there may be a paragraph in the judgment what you are referring, can the judgment be in conflict or in contradiction with the provisions of the Rome Statute or Rome Convention 68.3? It simply says that a victim can be a witness. And there is no whisper, there is no explicit or implicit provision that victim can be an expert.
Indeed, Your Excellency. Would you like me to answer the question? In Article 68.3, it states that a victim can be a witness. In the judgment that we were referring to, it stated that a victim can be an expert witness, an eyewitness, or in any capacity enter the court. Therefore, it wouldn't be in contradiction with the ICC manual. I mean, with the Rome Statute. Much obliged, Your Excellencies. Shall I proceed with my closing statement?
Yes, please proceed.
Much obliged. The occurrence of these efforts in the current situation can be seen by the survivor account of Miss Jean Thomas. Your Excellencies, if I may direct you to page 39, Annexure 4, Miss Thomas has stated that the most brutal hellfire was rained down upon them that any of them had ever experienced. She further mentioned that she had never before come across burn injuries of this nature in both her experience as being a medic or even as a victim. This has also been sufficiently and adequately proved in the witness testimonies by the answers that were provided by prosecution witness number 2 and victim witness number 2 in their chief and cross-examination. Your Excellencies, if I may direct you to page number 11, paragraph A. The accused was a commander for 13 years in the Republican Army and was a bomb expert. In his cross-examination, the accused accepted that there were other commanders who received these orders from Mr. David Wallace, but it was specifically him that chose to use thermobaric bombs. He further accepted that no other commanders had faced consequences of their actions, though they did not follow the orders of a superior. The fact that despite knowing this, he chose to attack civilians represents a clear mens rea on part of the accused. Your Excellencies, regardless of the illegality or legality of thermobaric weapons, it is submitted that the use of a weapon on innocent civilians can never be justified. At this juncture, the victim's legal representative would request the court to turn to Article 75 of the Rome Statute, read with Rule 97 of the Rules of Procedure and Evidence by the ICC. The victims are entitled to receive just and fair compensation for the losses of lives and property suffered by them as prescribed under Article 75 of the Rome Statute. The victims, being civilians, have been object of military-grade targeted attacks through the use of weapons. Hence, the victims are eligible to receive reparations from the accused, and in the alternative, the means for restitution and rehabilitation can be provided from the court's trust fund as under Rule 98 of the ICC Rules of Procedure and Evidence. The decision of determining the degree of damage caused and the appropriate remedy for the same lies with the court, and therefore we humbly request the court to exercise its sound discretion in ordering such compensation and reparation. Your Excellencies, the victims are the heart of the international criminal justice system. Therefore, with your permission, may the Council move on to the prayer.
Before that, I'm sorry, Ms. Counsel, I have one question. Because in response to your categorical question about his actions and following of his superior instructions, the witness has, the accused has very categorically said that there are incidences of taking action against the commanders who have not followed the higher-ups instructions. In view of these specific admissions, how do you justify your averment against the accused that he is responsible individually for the actions done? Thank you.
Indeed, Your Excellencies, the witness statement stated that in the past there has been actions, but he stated clearly that in this present case there haven't been actions taken against against commanders that chose to not answer superior orders. The siege of Emerald happened in 2022. We are currently in 2023, which means that there were more than 4 months for the Ministry of Defense to take action against the commanders. Seeing as they still haven't done so, it can be reasonably inferred that the accused was never under a threat to life in the present case. Much obliged, Your Excellencies.
Is it to be an immediate threat or an imminent threat?
It is to be an imminent threat, Your Excellency.
It's not to be an immediate threat, right?
No, Your Excellency.
So would it not be a situation of imminent threat rather than immediate threat?
In the present case, the Council will submit that it was not even imminent threat because In immediate threat, we would be looking at a matter of days. In imminent threat, 4 months have passed and still no action has been taken, despite action having been taken in the past. That points to the fact that the accused was not under a threat to life in the present case.
So what was the time gap between the attack on Titan and then the reaction to Titan, the way he responded?
Your Excellencies, between October 25th and 22nd and 25th of 2022 is when the thermobaric weapons were deployed. The time gap between the time gap that the accused had to prepare was half a week.
Yeah, and you said 4 months. I mean,
4 months from the attack being carried out till today, at which point still no action has been taken against the other commanders.
But no reason, because he's delivered, right? So there's no reason to expect that he would be tried by his superiors, because he's delivered on what his superiors wanted him to do.
Indeed,
So which
Your
rather all the more reason for us to think there's probably good reasons to think if there was imminent threat.
Indeed, Your Excellency, the Council was referring to the imminent threat on the other commanders of the military that received the same directive, but still no action has been taken against them, despite them not carrying out the directive.
They have failed to carry out the directives?
Indeed, Your Excellency, because they did not deploy thermobaric weapons. The accused was the only one who did so.
No. Have they failed to carry out the directives that were given to them?
Indeed, Your Excellencies.
Where is that? Which is it?
It comes from the evidence of Paul Anderson.
Indeed, Your Excellency.
Dr. Rajput.
Which page is that?
Your Excellency, the accused admitted to it in cross-examination. I
thought he said that there was a looming threat, and there was a possibility that he might be.
There was a looming threat. Indeed, Your Excellency, the accused testified there was a looming threat on him, but he also testified there were other military commanders that received the same directive that didn't take actions, and no harm has been done to them in regards to the threat to life that was on him. Therefore, the Council is submitting that there was no threat to life to begin with, and the accused took the orders in his own discretion.
So you're relying on the oral evidence?
Indeed, Your Excellency.
That's what I was trying to understand. I wish you had said that before. It would have made our life simpler. Thanks. You can move on.
You have to complete now, Council. I'm sorry that we intervened, but your time's up. Can you complete now?
Indeed, Your Excellency, the Council was done. If you would prefer the Council move on to prayers, or in the interest of time, the Council is happy to stop submissions.
Thank you.
Thank you.
Who's next?
Your Excellencies, am I audible and visible?
Yes.
May I begin? Okay, thank you. Your Excellencies, the present case is nothing but an attempt to frame the accused of crimes that were not committed by him. All the actions carried by my client were in pursuance of lawful military objects under the explicit superior orders as mentioned in Article 33 of the Rome Statute. The prosecution's case is to prove beyond reasonable doubt the guilt of the accused. However, in the present case, the prosecution has the opinion that the defense has the opinion that they failed to establish the guilt under Article 8(2)(b)(20) or 8(2)(b)(1) and has thus failed to discharge its burden. Consequently, the court ought to assume the innocence of the accused, as has been established under Article 66 of the Rome Statute. Now, before the defense moves on its arguments, it would like to point out some disparities that have been brought by our fellow counsel for the victims in their closing statement. They have repeatedly mentioned that there were other commanders that had disobeyed these orders of the superior and had not faced any consequence of the similar. However, there has been no statement made of any disobedience by other commanders who have not been executed or so this has been a clear misconstruction and has been a twisting of words of the accused in the cross-examination, as the accused has no statement made that to his knowledge there were other commanders who had not followed these orders. Similarly, both my fellow counselors had stated that the accused failed to distinguish between combatants and civilians in the present case. However, the accused as well as the counsel for the defense maintained.
Counsel, I'm so sorry to stop you mid-flow. There seems to be a bit of confusion as to what the directive was, what the lack of compliance was, and what the potential consequences are. Is it your position that there was a directive to use thermobaric weapons or not?
Your Excellencies, as per the compromise, the directive was to draw Titanian blood and to avenge the lost lives of Republicans in the light of seizure of emerald.
So is it your position that there was an element of choice as to how this directive was to be implemented?
Your Excellencies, as has been mentioned by my defense witness 2 and the accused in the chief in examination, the resources that the government provided during that very small period of 1 week pushed them and indirectly pointed them towards the creation of these thermobaric weapons, and thus indirectly forced them to use these in thermobaric weapons for the deployment after the siege of Emerald.
But it didn't somehow force the other commanders to use thermobaric weapons.
Your Excellencies, in the present case, the accused, the government specifically targeted these resources towards the accused because of his advanced knowledge of these weapons in his training time, during his training days.
Thank you. Thank you. You can move on.
Thank you, Your Excellencies. Your Honors, we shall be establishing that the charges under Article 8 to B20 and the Article 8 to B1 must not be confirmed. A second submission shall be that he committed these acts under superior orders and under duress and imminent threat. As to the charge under Article 8 to B20, holding Paul Anderson liable, the counsel prays that the accused is innocent as the subjective elements of the articles aren't satisfied. The counsel for the defense submits that firstly, the weapons used by the accused were not of the nature to cause unnecessary suffering or superfluous injury. Now, to weigh a weapon as a warfare that causes superfluous injury, following factors need to be met. A, whether the use of the weapon with such an effect is not absolutely necessary when measured against the military objectives to be gained from the use, and B, when the weapons are analogous to other weapons which have already been prohibited. The attacks were aimed at a legitimate military object and under military necessity, and the loss of civilian objects, if any, was collateral damage, and civilian casualties, if any, were only incidental, for which the accused cannot be charged under Article 8 to B1. If the prosecution or the counsel for the victims wishes to charge you for the incidental loss of civilian life, if any, they must add it under a separate charge. And since it hasn't been charged, and no separate charge other than 8 to B20 has been added to the present trial, the accused cannot be held liable for any incidental civilian casualties, if any.
If I may, if I've understood you correctly, you're trying to draw a connection between a superfluous injury and military necessity, to the extent that if there is a military necessity, the extent of injury caused is immaterial. Now, that's, I mean, what is the basis to support that argument?
Your Excellencies, if with the present factual scenario, if we see that
sorry, in law, what's there to say that you can cause superfluous injury irrespective, as long as it's a military necessity?
Your Excellency, the definition of superfluous injury itself says that if it is superfluous in the sense that if it goes beyond military objectives. So if these if the actions of any military commander or army personnel is within the lines of these military objectives, then they satisfy, ipso facto satisfy the need for military necessity, therefore justifying its use.
No. It seems maybe I'm myself not clear. Which provision are you relying on? Let's get back to basics. Which provision are you relying on to make this argument?
Additional Protocol 1 to the Geneva Convention, Your Excellency.
Yes. Which provision of the Additional Protocol 1?
Your Excellency, could we send a clarification via the chat box in?
Yes, please. Yes, please. I would appreciate that.
Definitely, Your Excellencies. Thank you so much. If there are no further questions, may I continue with my closing statement?
Yes.
Thank you so much. The civilians acting as eyes and ears of the Titan army military were sources providing regular intelligence on Republican forces, such that their every move was being constantly monitored and reported by these civilians, and consequently, these civilians posted a threat to the very survival of the entire Republican army, and hence they qualified as a legitimate military target. The accused said in testimony that there was no need to distinguish between such civilians in men in uniform, given that all of them were combatants in regards to the use of social media. The counsel further submits that for indiscriminate attacks, there are only limited categories of relevant sources that are considered inherently indiscriminate, like dum-dum bullets, V1 rockets, and poisonous weapons. Thus, given the categories of weapons failing afoul of these principles are extremely limited in the ICC jurisprudence and state practice as well, the prosecution cannot establish beyond reasonable doubt that such weapons are to be necessarily branded as inherently indiscriminate. The objects of attacks were legitimate military objects. Thus, the illegality of thermobaric weapons cannot be conclusively commented upon in a situation wherein the very survival of the entire army is at stake. Nuclear weapons have been indisputably branded as the most dangerous weapons on Earth, and thermobaric weapons are not comparable with nuclear weapons by any means. Given that the ICJ failed to categorize nuclear weapons, despite being aware of its uniquely awful long-term catastrophic effects, including jeopardizing the natural environment and destroying future generations, thermobaric weapons, which fall short of nuclear weapons in the term of its characteristics and yield most certainly cannot be considered indiscriminate per se. Further, to address the question posed by Your Excellency in the opening statement of my co-counsel, the Council submits that the requirement of inclusion of weapons in the annex to the Rome Statute is a conjunctive requirement. Article 8 to B20 poses a twin set of elements. The first part of the sentence is superfluous injury or inherently indiscriminate. However, the second sentence joins the elements of comprehensive prohibition and inclusion in an annex by the word and instead of or between the second part. It is a fundamental principle of statutory interpretation that in case of a conjunctive threshold, the coexistence of all the conditions that it enjoys together need to be fulfilled. In the present case, given that the state parties have included the use of thermobaric weapons in the annex to the Rome Statute, there is neither any evidence of an opinio juris or any ban under conventional international law which establishes the requirement of a comprehensive prohibition of thermobaric weapons. Thirdly, the Council submits that the acts fall under the defense of superior orders as there was also a situation of duress. The defense of superior order recognizes that the subordinates within the militia have little to no discretion in questioning the orders of the superior. With such a strong hold of David Wallace over the accused, along with the power disparity between them, there was considerable grounds to establish that the disobedience could have resulted in his imprisonment or even in execution, as mentioned by the accused himself. The defense submits that Paul Anderson acted on the faith that the orders issued by David Wallace are lawful, as firstly, he acted on the fact that the line of distinction between civilians and combatants was not required, and secondly, he was certain that no international instrument prohibited the use of these. Lastly, the Council, due to the paucity of time, the Council finally submits that to establish that the intent to add charge Article 8 to B1 of the Rome Statute pursuant to the legal recharacterization is not correct. In the present case, given the conduct of the civilians was tantamount to the direct participation in hostilities, they lost their predicate status and consequently became military objectives. As evident from the testimony of the accused, there was no need to distinguish between civilians and combatants, as any person with a mobile could cause harm and directly report the location of the Republican Army. With that, I conclude my closing statements. Thank you, Your Excellencies.
Thank you.
Very sorry, I know we are way over time, but I'm still struggling with this freedom to cause superfluous injury just because it's a military target, because you still haven't given me the legal provision. Do you have it by hand?
Yes, we're just sending it through the chat box. Just give us 10 seconds, Your Excellency.
I don't think it's possible because 35 is the basic rule. You should not cause superfluous injury. And military necessity is a basic rule under 48, and they have to be reconciled. It can't be the military necessity allows you to simply take over and cause whatever you like, destruction you like. I mean, that's a commentary. That's not, you haven't given me the page number either. I mean, I have the first additional protocol in front of me. So I'm not convinced by the argument that you can cause as much amount of injury you want just because it's a legitimate military target.
Your Excellency, if I may.
Yes, please.
It's page number 528, paragraph 602 of the book. If you are available, if the book is handy with you.
Could you just quickly read the relevant lines because we are short on time? Just the relevant lines.
Unnecessary suffering or superfluous injury may be understood as suffering or injury that is disproportionate and excessive in relation to the lawful military advantage pursued.
Yes. How does that allow you to cause superfluous injury just because it's a legitimate target? You're using the reverse argument of what is being made there. I mean, it would be unconscionable for me to say you can cause as much injury as you want, despite a very clear mandate of the basic rule. But be that as it may, it's an academic commentary which at least I don't find myself in agreement with. Thank you.
Thank you, Excellency.
All right, can we have I think we've heard from all council now. All three councils. So where's our manager? What's the next step here?
I imagine now we withdraw and deliberate, but
Yes.
Yes, sir.
Just a moment.
Just a moment. It has indeed been a fierce intellectual combat. I congratulate all the finalists for displaying commendable advocacy skills backed by impeccable research and analytical prowess. Benjamin Franklin has said that there is endless scope of improvement as perfection is a myth. In the spirit of such improvement, I would now like to invite the judges to provide constructive feedback to the finalists pertaining the oral rounds. However, we sincerely request the judges to not disclose any details pertaining to the outcome of the final rounds.
All right, just move the judges to the deliberation room now, please.
Judge Pillai, I think we're supposed to give feedback beforehand, or maybe I misunderstood.
We can't give feedback, we haven't deliberated. You can't, individual judges are not going to give you feedback. It's got to come from the bench as a whole.
All right, ma'am. With this, we conclude the final round of the 8th edition of Symbiosis Law School Pune International Criminal Trial Advocacy Competition 2023. I would like to put on record our never-ending gratitude for all the judges that have graced this competition with their presence. The judges shall now be assigned a separate breakout room for deliberation. I request the judges to join the breakout room by clicking on Join button, which shall appear on the screen shortly.
All right, good evening and a warm welcome to the valedictory ceremony of the 8th edition of the Symbiosis Law School Pune International Criminal Trial Advocacy, SICTA 2023, in association with SIN litigators, SLS Pune alumni, EBC Reader, and SEC Online. We have had 3 days of competition revolving around the themes of a theory of prohibition against the use of thermobaric weapons using the existing framework of applicable treaty and customary law, and the impact on the legal status of a non-combatant that civilians enjoy under the international laws of war due to participation in hostilities through social media conduits. This edition of SICTA witnessed participation from 24 teams from India and abroad. The 3 preliminary rounds were organized over a course of 2 days with a panel of 16 esteemed judges, and the final round was adjudicated by an illustrious panel of 5 panelists, including Dr. Navi Pillai from the International Court of Justice, Mr. Puvudu Sachidanandan from the ICC, Dr. Aniruddha Rajput, who is an Indian legal scholar and a renowned expert in international law and a former member of the UN International Law Commission, Dr. Ramajoga Rao Kasibatla, additional legal advisor at the Ministry of Law and Justice, Government of India, and Professor Dr. Sanoj Rajan, a renowned legal expert in the field of international law and human rights, and a distinguished professor of international law and human rights at the Zhejiang Gongchang University, China. The finalists of the competitions were from the teams from Jindal Global Law School, Christ University, Bangalore, and National Law University, Delhi. Now, to deliver the welcome address for the valedictory ceremony, it is my privilege to introduce Dr. Shashikala Gurpur, Jean Monnet Chair Professor, EUC LAMP, co-funded by the EU, Fulbright Scholar, Director, Symbiosis Law School, Pune, and Dean, Faculty of Law, Symbiosis International Deemed University. Dr. Shashikala Gurpur is a distinguished academician and orator, having presented more than 325 invited lectures, workshops, and seminars across the world. She's a pioneer of EU legal studies in India. With more than 27 years of teaching experience, which includes 10 years ranging from NLSIU Bangalore to University College Cork, Ireland, she has more than 80 articles and research papers, 2 co-authored books, and 15 book chapters to her credit. She has guided national award-winning projects on community-based legal reforms for national law schools. She acted as an advisor to research projects and publication of Asia Network of Women in Communication, sponsored by the WACC UK. She has achieved community legal service project grants from 2007 till now. And in SLS Pune, she has received 3 minor research projects of SIU and 2017, an Erasmus Mundus European Studies Capacity Building Program with 6 countries cooperation grant for SLS Pune. Dr. Gurpur has been a former member of the Law Commission of India and is currently a member of the Curriculum Development Committee, Bar Council of India, and the Academic Council of National Judicial Academy, Bhopal. She has been invited to be a member of the International Advisory Board of the CCLE, Centre for Common Law in Europe, UCD Sutherland School, Ireland, for 3 years. She has been appointed as a distinguished member of the editorial board of the Cyber Law University International E-Journal, Association of Young International Criminal Lawyers, Asian Law Institutes, Faculty of Law, NUS, Singapore, to name a few. She has been conferred with the annual Kittur Rani Chennamma Award in 2018-19 by the government of Karnataka for her excellent achievement in the field of education and contribution to women empowerment. She has been nominated as the member of the MCCIA Corporate Legislation Committee, and she's a project manager for 4 EU projects undertaken at SLS Pune and the chair professor for Jean Monnet Chair on EU Climate Justice, Law, Governance, Management, and Policy. It is an honor to welcome you, ma'am. I would like to hand over the podium to you to deliver the welcome address.
Good evening, one and all, and good afternoon to Professor Navi Pillai. It's such a humbling experience to, let us say, face such a distinguished panel, which is here now, including our chief guest, Justice Pushpendra Singh Bhati sir. First of all, a very warm welcome to Justice Pushpendra Singh Bhati sir, who is going to be the chief guest of this evening's valedictory ceremony, which will have the privilege of announcing the best international trial advocacy mooters or advocacy participants in this great event, which took place over the last 3 days and which had distinguished participation from 8 top law schools of the country, including a few others, and a team from Nepal, a team from Bristol, and a team from Johannesburg. So this way, this year's SICTA has covered almost major parts of the world, and it has been very, very, I think it is the last online version, hopefully. In these online versions, it has been very privileged to register such a participation. In addition to that, the judging panel, which judged the finals, has had great people which included Professor Navi Pillai, who has dedicated her life to the study, research, and practice of human rights alongside lawyer Pubudu Sachidanandan, advisory to Government of India lawyer Mr. Kashi Batla, and Anirudh, our own Anirudh Rajput, who has been with us in earlier occasions also, among others. We really missed Miss Fatu, whom I met in Ireland, and I felt that she is another person like Dr. Navi Pillai, kind of walking manifesto for dedicating one's life to the cause of justice on the face of inhuman crimes against humanity. Now, coming to this occasion, I should share with you, and I'm very privileged to share as the person in charge of this whole administration of this institute, that Symbiosis was born in 1971 as a network of students in Pune. Part of them were the students mostly from the African continent who faced a kind of excluded kind of treatment at the hands of the Indian students. So Dr. Muzumdar sir, who was then the rector of Ferguson Hostel and was also a botany professor, took it as a cause upon himself to give the voice to these voiceless students by creating a loose network of students called Symbiosis. So Symbiosis was involved in celebrating festivals. Then it started with English language teaching to assimilate these students into the landscape of Pune. which later created first of its institute in the form of this law school way back in 1977. That time, Pune had only one law school, the ILS Law School, which produced great luminaries, including the then Chief Justice, Justice Chandrachud, Senior, and it had many other credentials. But coming into the forum after 50 years of its existence, Symbiosis proved its mettle within no time. It was also because Symbiosis, along with the law school and management and IT school, became the deemed university by conferral of this honor by the government of India for the excellence of these three institutes. So this law school is very, very unique. First of all, it's in the private sector. Secondly, it is in the company of excellent institutes of management and technology, and now with medicine. Thirdly, it is founded and patronized with the vision and values that Dr. Mazumdar sir and his daughter Dr. Vidya practiced for very long in their home and in their life. So this law school also has in its DNA the idea of internationalization. So we won the internationalization award in 2020 when competing with the disciplines of medicine and engineering across the country by FICCI, the national body. We have had many distinctions as the law school. Whatever Professor Lasya read out as my CV is no personal achievement of mine. I should say that those achievements were possible because of the excellent students we received. Every year we receive about 20,000 applications for the 300 seats that we have. And the cream of Indian student milieu chooses to study here, even though they have other choices in the country with 1,500 plus law schools. This year, we are celebrating the unique distinction of being awarded the third best law school in the country, missing the topmost position by a whisker. And I'm sure that the innovative experiments that are going on, the excellent support we receive from the judiciary, the executive, the community, and the vulnerable in Pune will definitely make us to strive for excellence from year on year. I'm very happy to say that this is the law school which produces full-rounded professionals who fit into diverse legal careers ranging from corporate to judiciary to practice, and at the same time is distinguished for its community service with the prisoners, with the sex workers, with the underprivileged in the Pune city, and starting a very unique experiment called Barefoot Lawyers, where illiterate women of village have been selected, trained in legal knowledge, and built the capability to espouse causes which are important, such as child marriage, or the cause which led them recently to shut the liquor shops in the village because they thought that this is also one of the causative factors for violence at home. So we don't rest on our academic accomplishment or great infrastructure or the world-class facilities and the faculty that we have. We believe that you have to do good to the community to be well in your profession. So we have had collaboration with the District Legal Aid Services Authority, which resulted in more than 100,000 disputes resolved every year, with our students and faculty taking active role alongside the district judge and his team. Now we are embarking on starting our work with Aga Khan Palace, which is one of the reception centers for refugees. And right now we have signed an MOU with the district mental health care services. It is very heartening to note when one of the Supreme Court judges praised us for the initiative we took, which was brought to his attention, where an elderly woman was provided with her unique identification card, which entitled her to government scheme because of the intervention of our faculty and students, to mention one of the 100 issues we handle here. So Madam Navi Pillai, Advocate Sachidanandan, Anurag, and also Justice Sir. This is such a unique blend of a legal institute which embarked on this journey of organizing this competition. I must also say this wouldn't have been possible but for all the stakeholders coming together and facilitating their energies to flow and take this college's endeavors to the next level in internationalization. Now, what is that? We have here on the panel Advocate Manan. We have on the panel Advocate Sampath Bulusu, who are one of the two, especially Sampath Bulusu, who started it from the beginning. Manan joined the bandwagon recently on this cause of bringing this unique trial advocacy competition. We had bidded for ICC national representation, but being a private law school, our voices were feeble. So our students took it as a challenge and they came up with this problem. Our own student Parth at that time, barely in third year, drafted the problem, which was evaluated by international experts, our collaborative law schools in New Zealand and other places, barristers, etc., who were astonished at the professionalism and the perfection of such a problem. So such was the expertise that we were privileged to have within the institute. Even today, Parth participates, is a very successful professional. But this year also, from the time of, from drafting the problem, getting it assessed, and then from the inaugural till this minute, Parth is with us. So such is the dedication of our stakeholders, because of which it has been possible. I'm giving this long welcome address, interspersing these truths with you to show only that I don't think the time of us as giving knowledge is still there. It is a time when we discover knowledge together. It's facilitation and it is learning. Therefore, it's a great learning for us to see the commitment of our stakeholders and the expertise that they could bring, which is much better than the expertise with which we sent them away from this law school as finished products. I'm very proud today on behalf of my management, our university, and my office and my team of faculty and our deputy directors, Dr. Mohanty and Professor Kshitij, alongside the three young faculty who are leading this Student Bar Association as advisors, that is Professor Shubham, Professor Virendra, and Professor Prachi, that this couldn't have been possible for a brilliant teamwork, which is usually missing in our profession because we are a profession of individualism, competition. From there to switch over to collaboration, we had to set role model by showing the way, knowing the way, and going the way. So you would see our students also becoming excellent mediators, arbitrators, alongside other things. So I'm very happy to welcome you all, esteemed panelists who have honored us with your expertise in taking this cause further from your rich experience, your rich knowledge, and the proven capabilities at the global level. You have made us proud. You have enriched our participants' knowledge and our team's knowledge also when you all were writing and collaborating. Aside, I mean, our student Vikas Mandal was the one who was, Vishal Mandal was the one who was doing most of the communication. I really put it on record with a lot of sense of gratitude because he took this initiative of identifying names, although some of them are familiar with us. But on top of that, keeping that grit and communication and your kindness, despite your busy schedules, to encourage these students is really praiseworthy. Justice Pushpendra Singh Bhati, sir, sir, your commitment is also one of the rarest to be commended here and to be welcomed. Sir, we have had this kind of trajectory because of some of the judges of your excellence who came to us as parents, as friends, and as invited guests, who gave us suggestions on the curriculum, on pedagogy, and engaged here with classes and engaged our students as clerks and interns. Otherwise, I don't think this fiat would have been possible for us. So this is an accumulation, as they say, you know, the real knowledge accumulates and the guru works with the students like in the sense of a honeycomb, that all these honeybees collect honey from everywhere. So today is that kind of a celebration that a guru says that my job is like a honeybee. I'm a madhukar vritti, means my profession is like a honeybee. I collect the madhu or the sweetness from everywhere. So it is the sweetness of your generosity, the sweetness of your wisdom and knowledge, which has brought us here today, and the sweetness of the love that our alumni have and the experts who acted as semi-final advocates, semi-final judges. Some of our excellent alumni acted as the semi-final judges, and then you all came in the final along with sir to honor us in the valedictory ceremony. A warm welcome and a humble salute to each and every one of you. Welcome.
Thank you, ma'am. Thank you for that apt welcome and setting the tone for this valedictory ceremony. Dr. Gurpur is a driving force behind all the achievements of the Faculty of Law at Symbiosis, SICTA certainly being one of them. So thank you, ma'am. It is now my privilege to introduce the guest of honor, Mr. Pubudu Sachidanandan, trial lawyer for International Criminal Court, Hague. Mr. Pubudu Sachidanandan received his Bachelor's of Law as well as Master's in Law degree from the University of London. He did his Master's in International Human Rights from the Human Rights Law from the University of Oxford and pursued further executive training programs from Harvard Kennedy School. He served as a trial attorney in the Office of the Prosecutor for the International Criminal Tribunal of Rwanda, and he went up the ladder in the International Criminal Court, serving as a case manager, assistant trial lawyer, and an associate trial lawyer, to today being a trial lawyer for the International Criminal Court at Den Haag. A very warm welcome to you, sir. I would like to welcome you to deliver the guest of honors address.
Thank you so much. Can you hear me?
Yes.
Okay. Let me begin by saying, you know, I judge many moods because it's a passion of mine from law school onwards. But this is one of the first times that I'm judging one which involves South Asian students. And that makes me tremendously excited. It's in a world where public international law and international criminal law is such a Eurocentric field that this is tremendously exciting. That a part of the world which has something like half of the world's population is becoming involved and taking this field in its hands and watching the students today move with such confidence, such a grasp of the law and the facts was tremendously inspiring, I have to say. And having been a prosecutor for some 20 years, I must say that I'm really looking forward to the day when I can see one of you across me in an ICC courtroom and address you as a learned friend. You know, there are, of course, learning opportunities, and I'm sure we can have a chat about those when and if anyone is interested. You know, there's always opportunities to learn, regardless of whether you are 23 years old or slightly older, in my case. And I also wanted to say that if this has kindled in you, if being on your feet, talking about these issues, examining victims or playing a victim or examining experts, if this scenario, really excellent scenario, I must echo the previous speakers, if this has kindled in you an interest in international criminal law, or an interest in international humanitarian law, or an interest in international human rights law, I must tell you that it's a fascinating and vibrant field. There are many, many vulnerable people around in conflict zones all around the world, victims of all kinds of exploitation and discrimination in our countries and elsewhere. So please then follow that dream. And if you want any assistance in following that dream, please reach out to us, the judges on your panel, and we will do the best we can to support you in achieving that endeavor. I recall as a student, I used to really dislike it when speakers went on and on. So I will end now. But indeed, I really look forward to the day that I can see one of you across the courtroom and address you. Thank you so much for having me.
Thank you so much, sir. Thank you for your encouragement and for giving a glimpse into the world of international criminal law. Your presence and your participation in this really means a lot to all of our participants and the students who have been a part of this. Thank you very much. It is now an honor for me to introduce our guest of honor for the valedictory session, Dr. Aniruddha Rajput, former member, United Nations International Law Commission. With a master's in law from the London School of Economics and Political Science and a PhD in international law from the National University of Singapore, Dr. Rajput was the chairman of the drafting committee for the 69th session of the ILC in 2017. He has advised governments on proceedings before the International Court of Justice, private clients on proceedings under the Alien Tort Claims Act before the US court, and human rights and other public international law litigation in the Supreme Court of India. He's a member of the Board of Studies of the South Asian University, created by the South Asian Association for Regional Cooperation SAARC countries. He was also the member of the study group constituted by the Law Commission of India in 2015 draft Indian model BIT. He was also a member of the 5th Haryana State Finance Commission constituted under Article 243 of the Indian Constitution. He has helped draft the arbitration and conciliation rules of the London Court of International Arbitration and the Delhi High Court Arbitration Centre. He was involved in the consultations for proposals of amendments to Indian Arbitration Act and contributed to drafting the National Sports Development Bill in 2011. It is truly an honor to have you amongst us, sir. Very warm welcome to you. I would now like to hand over the stage for you to deliver your guest of honors address.
Thank you very much. Distinguished dignitaries, ladies and gentlemen, it's an honor to be here. Maybe I should definitely be brief considering how much I spoke during the rounds. But I must say it was an interesting intellectual exercise for myself to challenge my intellectual understandings and to those of the participants. But before I make any brief comments, I must also express how deeply delighted and warm I feel to be in Symbiosis premises, although virtually. I never had the privilege of going to the Symbiosis Law School, but both my parents studied at Symbiosis Law School. So it gives me a feeling of a grandmother's home whenever I went to the physical premises of the Symbiosis whenever I could, but even virtually, it gives me a very warm feeling. So I'm very grateful to Professor Gurpur, to all the faculty, and in particular Professor Thakur, who has been corresponding with me and ensuring I'm here on time. So immensely grateful to all of you. I'm also very pleased to see the kind of interesting things, not just internationally, but also domestically, taking justice to those who really need it and where it matters the most. Otherwise, justice is pure theoretical conceptual exercise, not of much utility. So I'm very happy that Symbiosis is doing all these activities. And as Mr. Sachidanandan said, we're always there to help you in whatever capacity we can. I'll just make 3 brief comments. I hope they are helpful to all the participants. First, I think in any international law exercise, it is important to be fully aware about the law. Law is the starting point. Unless you have a good grasp over the law, you will never be able to play around with the law. So the first task is to understand the law, to absorb the law. Then you get to a stage where you can start playing around with the law. That's when you can ask some difficult conceptual questions. Ask yourself, put your opinion, as one says, take it out and hit it with a cricket bat to find out if your opinions and views are sound. So understanding of law is extremely important, which comes with extreme amount of hard work. All my research assistants who work with me often say, it's donkey hard work working with me and for me. So unless you do donkey hard work, you will not make much progress in international law. So know the law. But is knowing law enough? I mean, academics know it really well. With due respect, not all academics get into practice as a choice, but there's something more, something different apart from knowledge of law, which is required in order to be a practitioner. And that brings me to the second point, which is knowing the practice of law, knowing how a certain argument is going to run. It might sound very interesting to me because it suits my purposes. But is it going to be liked by the judge, who's a third-party arbiter, who's supposed to be independent and is going to cast an independent eye on the arguments that I'm going to make? So being practical about your arguments is extremely important. The third important lesson, if I can call it a lesson, is knowing the policy of the law. And knowing the policy of the law is knowing whether in a given context a certain argument is going to work or a certain argument is not going to work. Therefore, I often say as an academic, when you're doing academic writings, you have to make your best argument. But when as a practitioner of international law, You're not expected to make your best argument. You're expected to make a winnable argument. And that's the difference while you're working as an international lawyer in academic capacity and writing your academic articles, unlike when you're appearing before a court or a tribunal. This was just an experience. Of course, it's never as combative as you experienced, which has probably made most of it made combative by me. But I think that's just part of the exercise, but that's not what actual courts are going to run. You won't know what's going in the judge's mind, but it's helpful to be aware of the policy and the practice aspects apart from the law. But having said that, I must also say all of you, all the participants deserve immense amount of congratulation. The first congratulation is because you saw the notice board where there was this competition and you thought, let me give it a try. So for all those who made that brave decision, they all deserve congratulations. From those who made an effort, came here, pursued that, also deserve a congratulation. Now, in the world that we live in, we have to find winners. We don't have to find losers. We simply have to find winners. That's how competitions work. But it's not just an exercise of finding a winner. I think in today's exercise, anybody and everybody who participated became a winner, because in the process, international law has won. In the process, several new international lawyers have been created. Trust me, I always, whenever I meet my colleagues on the International Law Commission, meet eminent international lawyers and ask them, what was your starting point for international law? For some of them, it was the back of a textbook, which was written by an eminent author. They thought, well, this is a good book. And now they are the ones who are editing it or writing it, leading textbooks in Europe on international law. But for most of us, even some judges of the sitting judges of the International Court of Justice, introduction of international law was through moot courts. For me, the introduction was purely through moot courts. For many Indian students, it is through moot courts. This is the first opportunity. So you have latched on it. So you've become an international lawyer. So immense congratulations on that. It's just about pursuing the journey, pursuing the hard work. You may decide to stay in international law. You may not decide to stay in international law. But whatever you do, the understanding, the fundamentals, the principles of international law, the notion of rule of law within the international sphere in international relations is now engraved in your mind and in your personality. Whatever you do in a private sector, government job, lawyer, doing trial court, simple criminal matters, simple rent matters. I used to do a lot of them when I was practicing in the Supreme Court, or being a judge, or being an international lawyer, or one day opposing Mr. Sachidanandan. In whichever position you are, you've taken the first step. You deserve full congratulations. And I must say it was a great pleasure to hear you all. I'll be also failing in my duties if I don't congratulate Mr. Parth Dikshit, who's really put in the effort, the advisory board, the student committee who prepared this moot court problem, which was extremely impressive. And I must say this event wouldn't have been an event unless all those who are working behind the scenes worked so hard for it. So I must also take this opportunity to congratulate faculty members, students, everybody. I've myself done it when I was a student. I know what it takes. And it feels very nice to see the younger generations coming, taking up the mantle. And I'm very sure as you all have a bright future, and very soon the complexion of individuals who appear before international courts and tribunals would be far more diverse than what it currently is. Thank you very much.
Thank you so much, sir. Thank you for your encouragement, your insightful advice and provocation regarding the practical workings of international criminal law and what it takes to become a successful international criminal lawyer. Thank you very much. It is now my honor to introduce our guest of honor, Dr. Navi Pillai, Judge Ad Hoc, International Court of Justice, President, International Nuremberg Principals Academy. Dr. Pillai, supported by her local Indian community with donations, graduated from the University of Natal with a BA in 1963 and an LLB in 1965. She later attended the Harvard Law School, obtaining an LLM in 1982. With a Doctor of Juridical Science degree in 1988, Dr. Pillai is the first South African to obtain a doctorate in law from Harvard Law School. In 1967, Judge Pillai became the first woman to start a law practice in the Natal province, South Africa, and the first woman of color to serve in the High Court in her country. In 1995, Mandela nominated Dr. Pillai as the first non-white woman to serve on the High Court of South Africa. Her tenure on the High Court was short, however, as soon as she was elected by the United Nations General Assembly to serve as a judge at the International Criminal Tribunal for Rwanda. She served for 8 years, including 4 years as president. In February 2003, she was elected to the first ever panel of judges in the International Criminal Court and assigned to the Appeals Division. She was elected to a 6-year term but resigned in August 2008 in order to take up her position with the UN. The appointment of Dr. Navi Pillai as UN High Commissioner for Human Rights was approved by the General Assembly in 2008, and she took up the post in 2008. It's an honor for us and an inspiration for us to have you amongst us today, ma'am. I welcome you and hand over the podium for you to deliver your address.
Ma'am, will
Thank you, Lasya. Thank you, Lasya, for that lovely introduction and that you got all the facts right, the names of the courts and so on. I am very pleased to join the distinguished group of judges. I'm sorry I missed the people who judge the preliminary rounds, but at least on the final round, it was really a privilege to be serving with experts with knowledge of the law, practical experience, and so on. But I'm particularly intrigued with Symbiosis Law School. And I only got all that information now when Dr. Sashikala Gurpur gave us this big background. So all of that is new to me. And I really want to congratulate you and all the academics, students who have been on this campus for building this institution to where it is. So many people, particularly students in my country, feel things have to be done for them. They don't understand how much you could do if you take the initiative. I love your logo, your goals of care, courage, competence, and collaboration. I see all of that being acted out in moot courts such as this. So I want to make clear that I have benefited from participation. It's also through the wonders of technology that we can get together. India has a famous reputation for greatness in technology and your IT communications. I think the whole world respects you for that. Well, I've seen firsthand how this complicated moot court session involving so many peoples was done so competently. I've been a lawyer, defense counsel for close to 30 years before I became a judge and an international judge, and I have participated in many moot courts. So I know what I'm speaking when I say that I really respect the quality and standard of the arguments made by every one of the participants whom we heard in the finals. Yeah, it really is awe-inspiring. It fills us with hope for the future if this is the quality of our young leaders of tomorrow. There is so much of negativity and depression in many parts of the world because mainly we do not have competent political leaders with vision. The world is involved in a war right now, and there are huge divisions. A Supreme Court is being threatened in one country, and in my country, we're battling with corruption, a former president who's now on trial. So much concern by civil society, much concern by young students such as you in my country who tell me, don't talk to us about human rights. We want to address the root causes, colonialism, and so on. But when students like you get together, despite all your disadvantages, and respond to the inspiration provided by your teachers, because that's where it comes from. If your teachers do not introduce you to international criminal justice, for instance, you wouldn't be where you are. So I always want to pay tribute to teachers. I had several interns from India when I was a judge on the International Criminal Court. And one of them said, obviously had read the entire Akiyesu judgment that we delivered in the ICTR. It's about 300 pages. So I was very surprised that she had read this judgment. And she said, well, the whole class has read it because we have young, vital, energetic lecturers who introduce us to these subjects. That is so important. I don't think you will find two students at universities here who are familiar with international criminal justice, let alone the jurisprudence I created outside the country. Very, very little awareness about that. So I'm taking all this time to pay tribute to where you are now and always encourage those coming after you to follow in your footsteps. On the final rounds, let me say that, we reached a decision by consensus, and it was not easy because there was so much competence in the room. And what I want to endorse is the quality and high standard of the preparation and the delivery. And I also agree that Parthy has done an excellent job in creating this simulated exercise. So thank you for that. That was my daughter calling, I apologize. So those are my few remarks, just to say I'm really happy that we were able to get together for this moot court hearings. Thank you.
Thank you, Ma'am. Thank you for gracing us with your presence and for your invaluable encouragement. Thank you very much. It is now my honor to introduce the chief guest for the valedictory ceremony, Dr. Justice Pushpendra Singh Bhati, Honorable Judge, Rajasthan High Court. With a BA LLB and an LLM in mercantile law and a PhD in promotion and seniority in public employment, its changing dimensions and the role Justice Bhati has practiced in the Rajasthan High Court, Jodhpur. He was appointed as Additional Advocate General, Rajasthan High Court, Jodhpur, and remained a panel lawyer for Keendriya Vidyalaya Sangathan, Oil and Natural Gas Corporation, Labour Department, Government of Rajasthan, and Ayurveda Department, Government of Rajasthan. He represented the Reserve Bank of India and was a standing counsel for Indian Railways for 16 years. He was elected as a member, Bar Council of Rajasthan from 2009 to 15 and as a president, Rajasthan High Court Lawyers Association from 2011 to 13 and general secretary for the Rajasthan High Court Advocates Association in 2000. The member and executive committee member of Indian Law Institute, Rajasthan chapter, and a member of the Supreme Court Bar Association since 1992. It is an honor to welcome you in our midst, sir. I would like to welcome you and request.
Hello, am I audible? Am I audible?
Yes, sir.
Thank you. Thank you so much. This is a wonderful opportunity for all of us to get together in the best interests of the students. Moot court competitions is always an opportunity, and as rightly been described by all the respected speakers, it is not only an opportunity, but it is a great moment. It sometimes become a turning point for the younger generation when they get a feel of the actual courts by way of moot court competition. Professor Lasya, Professor Sashikala Gurpur, Dr. Aniruddh Rajput, Dr. Navi Pillai. It was very interesting to hear each one of you and your thoughts. I must confess that I have been. Am I audible to all? Sorry.
Yes, sir. You're audible.
Okay. So this happens like this, that international court of justice and international law and international criminal justice and everything, all the international aspects of the law have gathered momentum over the years. 30 years ago, when I joined the legal profession, it was the international law was a backbencher, and mostly the students of law in India would not prefer to specialize in that because it would not create the kind of vibrance for the future of those students. But with the time, now it has changed absolutely. Now the best thing that has happened is that it has become a global world, and in this perspective, the moot court competition is of the topic of the moot court competition today is not only very significant, but it is very relevant to the modern times. The students of law have to be made aware of, have to be their skills need to be honed. They have to rise up to the occasion. Bar Council of India has recently announced the perspective of foreign law professionals coming into the country. This permission was long pending and had to come in a big way, and is bound to come and is on its way. And therefore, we have to all the more be responsible towards the entire world rather than being remaining in a small spectrum. I always had admiration for your Symbiosis Institute because some of the finest professionals who contribute a lot to Rajasthan High Court, which is a constitutional court, belong to our alumni of your institute. And I see how well they are doing, and I see how the university must be working on it. And Madam has just now informed us that it has completed about 50 years of its service to the legal education, which is all the more a very exciting proposition, because with these kind of institutions only we are going to shoulder the responsibilities of entering into the global arena of law and justice. For the students, I have a message, special message, and the message is that there are times of, this is a great, particularly the students of Symbiosis or any other law school in the country, these are times of change. Everywhere technology is changing. The Chief Justice of India is spearheading great technological leaps in the judicial system. Every lawyer, every corporate lawyer, every teacher, every stakeholder now needs to upgrade himself, including the judges, of course. In case we upgrade ourselves, we will be able to withstand the storm of change. And it is often said, when the storm of change comes, there are two kinds of people. One is who create stone walls to avoid change, another who make windmills. And please, let us all make windmills. Let us adapt the change. Let's go for it. The technology is here to stay. It came with the COVID. The thrust was given by the legal system all over the country. Today, there are concepts like live streaming, transcription, and e-courts, virtual courts. Even the last court of the country today is equipped to go ahead with the virtual courts and e-courts in technological sense, although adapting it will still take some time. The government of India is making a tremendous contribution for modernizing the legal system of this country in the best interests of the in the most important stakeholder, that is the citizen of India, that the citizen of the, it may be any country. And I'm sure this kind of contribution, we all will participate. I often remember the words of Justice Krishna Iyer, who used to say that in the changing times, we are not in these times. He used the words for constitution, but I use it for the technology. I borrow his words for the technology, that in the bus of technology, we are not mere passengers. All of us are crew, including all the stakeholders, teachers, universities, courts, judges, corporations, everywhere. I'm extremely happy to hear the all the speakers, because like we have in law a corporate social responsibility, it is the duty of every successful legal professional to contribute to the time and energy of younger persons who are developing persons, the students. Unless we contribute to their enhancement, to strengthening their roots, we would fail in our duties. We would be failing in our duty to create a fantastic legal world of tomorrow. Law is an essential component of society and it needs development. Unless we develop it with the pace of the society will suffer. The democracy will suffer. The constitution will suffer. The globalization process will suffer. Therefore, we cannot allow it to happen. And we all have to gather our strength like we have done today on whatever occasions, platforms possible, particularly when prestigious platforms like Symbiosis is offering us this good time to address the students, the stakeholders, the competitive in this competitive world, the kind of moot court competition that you must have done must have really given you a lot of strength. I congratulate each and every student who has participated. And one last message that I want to give each and every participant is that in law, the best practice, which is not there in anywhere else except sportsmen, that is that we respect our adversaries. That is the best practice that a legal mind has to adopt. We are thorough in our engagement while we contest each other, while we contest the rights of our clients, but at the same time, we have the ability and agility to be to adapt and to respect the adversarial views as well. So this is this fantastic phenomena which is called law. And all the students, welcome to the legal world. I, as a student of law, welcome you all. And I must admit that the credentials that your university, Symbiosis, which has been shared by Madam Gurupur, are extremely encouraging. And third law, it is third in the country. It's happy to know that. Someday, I will definitely request Madam that I should come there physically and meet all the students and maybe address a seminar or whatever could be. It is a wonderful institution, heard a lot about it, and hope someday we'll be there. All of you, God bless you. Keep strengthening yourself. Keep doing the best. Thank you. Jai Hind, Jai Bharat.
Thank you, Justice Bhati, for your time and your support. Honestly, your words of encouragement representing from the Indian judiciary are highly valuable to the whole of legal academia, certainly including Symbiosis Law School, Pune. Thank you very much for your presence today. We have now come to the time of the declaration of the awards for SICTA 2023. And for that, I would like to call upon Mr. Gaurav Lalwani, convener of the Student Bar Association for SICTA 2023.
Hello, everyone. Am I audible?
Yes, you are.
I am Gaurav Lalwani, convener of the Student Bar Association of Symbiosis Law School, Pune, and convener of the 8th edition of SICTA 2023. I would like to thank our beloved director, ma'am, the judges, sponsors, faculty members, who have been key stakeholders in this 8th edition of SICTA, which has resulted in a grand success. We shall now begin with the declaration of results for our flagship event. This year, we have been graced by several eminent personalities who have adjudicated the preliminary rounds, semifinals, and final rounds of SICTA, along with talented and competitive participants from both national and international institutions. B, as part of the SICTA OC, value the efforts of all participants and students who have acted as witnesses in this competition. After due deliberations amongst the judges, we are glad to announce the awards for this year's SICTA. The award for the best witness goes to Mr. Vikrant Dwivedi. The award for the second best witness goes to Mr. Yug Sinha. Moving ahead, the award for the second best student advocate shall be shared by two participants from SICTA 12 and SICTA 13. The student from SICTA 12 is Ayana Rai Bhojani from School of Law, Christ University, Bangalore. And the second team is SICTA 13, is Manas Mahajan from National Law University, Delhi. Moving forward, We would now like to present the Best Student Advocate Award to Neelabro Bhattacharya from RGNUL, Patiala. For the next award, we have our esteemed sponsor, Advocate Manan Sanghai, here with us. This award is presented by Advocate Manan Sanghai for Best Defense Advocate Award for the international team that goes to Sanskar Mansingh Basniat from Kathmandu University School of Law. Moving ahead, the next award is presented by Advocate Manan Sanghai for Best Defense Award for an Indian team to Hashvi Bansal. Hashvi is from RGNUL, Patiala. Moving forward, the next award is Shri P.V. Ramanaya Memorial Best Prosecutor Award for Neelabro Bhattacharya from RGNUL, Patiala. Moving forward, we are going for the Best Advocate Award in the final rounds of SICTA 2023, which is presented to Manas Mahajan from NLU Delhi. The next award, which is presented, is the second best memorial to Team Coach SICTA 10, which is NMIMS School of Law, Mumbai. Moving ahead, we would present the Best Memorial Award to Team Code SICTA 12, which is School of Law, Christ deemed to be University, Bangalore. This year, we have received a lot of international teams participating in the 8th edition of SICTA. Therefore, we have presented a new award in this edition, which would be the Best International Team. This award is presented to SICTA 24, which is University of Johannesburg. Finally, now we are moving ahead with the declaration of the results of the final rounds of this competition. The second runners-up is being presented to Team Code SICTA 12, which is School of Law, Christ deemed to be University, Bangalore. Lastly, we would now like to present the runners-up and the winners of the competition. I hope all the participants are ready for this announcement. Moving ahead, we have the first runners-up, which goes to SICTA 11, which is Jindal Global Law School. And finally, we would now like to declare the winners of the 8th edition of Symbiosis Law School Pune International Criminal Trial Advocacy Competition, which is SICTA Team Code 13, that goes to National Law University, Delhi. I would now like to congratulate all the participants who have put in their best efforts in participating in this year's edition of SICTA 2023. I would now like to pass on the mic to Lasya, Professor Lasya.
Thank you. Thank you very much, Gaurav, and congratulations to all the winners. It's very well deserved. Now, to deliver the official formal vote of thanks, I would like to call upon Dr. Aparajita Mohanty, ma'am, Deputy Director, Academics, Symbiosis Law School, Pune.
Thank you, Lasya. On behalf of management of Symbiosis, Dean of Faculty of Law, Symbiosis International University, and Director, Symbiosis Law School, Pune, Dr. Sashikala Gurpur, faculty and staff of our law school, it is my honor and privilege to deliver the vote of thanks. It's been rightly said that no enterprise or endeavor can be successful without active support of and collaboration with wide range of stakeholders. The 8th edition of SICTA, which was inaugurated on 20th April 2023 and reached its glorious conclusion today, bears testimony to this. I express a sincere vote of thanks to Honorable Dr. Justice
Pushpendra Singh Bhatti, Judge, Rajasthan High Court, for consenting to be the chief guest for the valedictory function of SICTA. Sir, your presence and words of wisdom and message will go a long way in inspiring the participants and the students who are in attendance. Sir, we assure you that Symbiosis Law School Pune is dedicated to build up the knowledge base, character and capacity of students so that they are able to face the ever-changing world with confidence and the necessary skill set. Thank you, sir. I thank Dr. Navi Pillai, Madam, ad hoc judge at International Court of Justice, Dr. Aniruddha Rajput, sir, former member, UN International Law Commission, Dr. R.J. Rao Kashivatla, additional legal advisor at the Ministry of Law and Justice, Government of India, Mr. P. Sachidanandan, trial lawyer at ICC, and Professor Sanoj Rajan, distinguished professor of international law and human rights at ZSU, China, for sparing their valuable time for judging the final rounds, as well as consenting to be the guest of honor and address the participants and the students in attendance. Thank you, Madam and Sir. This constellation of illustrious legal luminaries has indeed raised the bar and stature of SICTA. A warm note of gratitude to all of you. I thank all the judges and judges of semi-final and the preliminary rounds. A special note of gratitude and thanks to the illustrious alumnus of our law school and mentor of Student Bar Association, Mr. Sampath Bulusu, for visualizing and leading the entire team of judges in both preliminary as well as the semi-final rounds. Dr. Shashikala Gurpur wears multiple hats of being a dean, director, administrator, and mentor to both faculty as well as students. Thank you, ma'am, for your guidance and support in every stage of academic, co-curricular, extracurricular activities at our law school. Your passion for capacity building of our students is indeed unparalleled. Thank you, ma'am. I thank our generous sponsors, which include our alumni, Mr. Sampath, Ms. Advocate Harshad, Advocate Manan, Advocate Samir, parents, Mr. and Mrs. D'Souza, academic service provider, SCC and EBC. I thank the faculty team of SBA as well as student team of SBA for their exemplary work of coordination, dedication, and hard work, which was evident right from the process of conceptualization to execution of SICTA 2023. I thank the participants, both national and international team. I'm sure the very process of preparation for the topic leading up to the 2 days of intense competition must have been a great takeaway in terms of learning and development. Thank you to one and all. I thank all my colleagues and IT support team for providing assistance in multifarious logistics for the event. I also thank the student witnesses without whom the trial advocacy competition wouldn't have been complete. Last but not the least, I thank the students for attending both the final rounds as well as the valedictory ceremony. Thank you, one and all.
Thank you very much, ma'am. With this, we come to the conclusion of SICTA 2023. But before we can conclude the valedictory ceremony, I would like to request all the dignitaries, the guests of honor, and the chief guests, deputy directors, and the winners to kindly switch on your videos for a group photograph.
And the sponsors also, Advocate Sampath,